Please, Your Lordship. Regarding a fishery settlement matter, Your Lordship, we have already are trying to revisit the tender process, Your Lordship. May it be listed tomorrow, day after tomorrow.
You have to mention it before bench 4. This is not a bench 4 matter.
May please, Your Lordship. Lordships, that regarding additional affidavit filed by the respondent number 2 and 3 in item number 47, Lordship. Lordship, kindly we call for the records of the affidavit.
Yes.
My lord, I'm seeking your lordship indulgence to make a small prayer. Yesterday, I made a mention for listing of a new writ petition, and lordship was pleased to grant me to list it on Friday. My lord, as you have served a copy, my lord, the other side is aware of the, yes, my lord, we have assailed the election. And my lord, we have been informed that they are making a hectic preparation.
Except for making a prayer for unlisted.
No, unlisted, my lord. Tomorrow, some event is there, the appointment letter will be distributed, and they are making a hectic preparation to, my lord, appoint the private respondent therein. So, my lord, can it be preponed and taken up tomorrow, my lord? Otherwise, your lordship will.
You wait, there is a matter coming up today on that. I believe it is posted. After the order is passed in that, then you make a mention. All right.
May I please? Lordship, I beg to mention for listing this matter for motion tomorrow, Friday, Your Lordship. Contractual employee, Your Lordship, in the Department of PNID, Your Lordship. His service contractual agreement was terminated on the basis of an leaked video circulated in the social network.
Contractual agreements terminated when?
On 19/5, Your Lordship, and video was circulated on 18, Your Lordship, without giving any opportunity of hearing and notice, Your Lordship. On
Monday,
Your Lordship.
Monday. Yes, next matter. Please.
I would like to mention one writ petition regarding non-payment of family pension, Lordship. Petitioner is widow. It was listed 6 February, but did not reach, Lordship. So
Give her the number, it will be listed on some day. It will be
on
listed.
the 2nd of June, Lordship.
Yes.
May please, I beg to mention for listing on admission matter. Next week, any date, ma'am?
No, after 2nd week of June.
After 2nd.
May please, Your Lordship. In item number 46, we have filed an objection to the IA, Lordship, may be permitted to bring on record.
Yes.
In item number 53, I have filed an additional affidavit. It may be called for record.
Please, Your Lordship, I beg to mention item number 39. Lordship, the matter may be adjourned for a week. We are having some difficulty today.
Item number?
39. In today's list.
It has come for orders.
Yes, Lordship.
Why you want? Let us see. Let the matter be called up. Then we'll see. What order?
Today, my senior is not there.
You are there. You did it.
Yes.
May I please, Your Lordship? Lordship, I beg to mention item number 44 of the daily list. With the consent of the opposite side, I am seeking adjournment for filing a additional affidavit.
You are for the petitioner.
Petitioner, Lordship.
Is there any stay order?
For filing additional affidavit,
Is there
Lordship.
any stay order operating in this case?
No, Lordship.
All right. On the prayer of learned counsel for the petitioner made with the consent of the other side, this matter stands adjourned for 2 weeks so as to enable him to file additional affidavit.
God bless.
May I please, Your Lordship? I beg to mention for listing of a WPC Lordship. It was not listed till 2021 Lordship. We have also mentioned to the registry and given application.
3rd week of June. You put a
Third
date, 3rd week of June.
Published.
May I please, Your Lordship? I beg to mention item 28, Lordship. Kindly adjourn the matter for the day, Lordship.
You are for whom?
Yes, I'm appearing on behalf of my senior, Lordship.
Your senior is for whom?
Ida Fake, Lordship. Ida Fake.
On the prayer of learned counsel for the petitioner, admission hearing of this matter stands adjourned for 2 weeks. Yes.
Yeah, please, Your Lordship, I beg to mention item 34 of today's list. The council is not well. Kindly adjourn the matter for 2 weeks and the interim be continued.
You are appearing for whom?
ST Bok.
My lord, in this case, I am applying for respondent number 5, my lord. There's a stay order, my lord. May I apply for a fixed date because my service has been refrained, my lord.
All right. On the prayer of learned counsel for the petitioner, this matter stands adjourned till 7th of June, 2023. Mr. G. Alam, learned counsel for the private respondent is present and has expressed urgency in the matter. Yes.
Obliged, your lordship.
Obliged, ma'am.
Mhm.
Lordship, I may be allowed to withdraw this application.
All right, Mr. M. Sikal and counsel for the petitioner.
Liberty may kindly
No,
withdraw.
then you have to argue why you want to withdraw. If you want liberty, then you have to convince the court why you want to withdraw.
Lordship, one important document which will be requiring to submit. Lordship, she must not affix with the record.
Yes,
So, Lordship,
Mr. Dhar. Mr. M. Sikal and counsel for the petitioners seek leave of this court to withdraw this writ petition with liberty to file afresh after incorporating a vital document. Since the prayer is not opposed by Mr. R. Dhar, Leonard, Government Advocate Assam appearing for the official respondents. The same stands allowed. Writ petition stands disposed of on withdrawal with liberty as paid.
I do.
Top of the list, item 1. May I please, your lordship, this matter, it has been become infructuous, my lord.
Miss
B has it.
B. Hazarikal and counsel for the petitioner submits that the writ petition has become infructuous. Mr. N. Upadhyay.
1 and 2.
Standing Counsel Irrigation Department is present on behalf of respond numbers 1 and 2. And Mr. S. Banik, Learned Counsel for the respond number 3. First, in view of the submission made by the petitioner's counsel, this writ petition stands. Infructuous.
Motion item 2.
The challenge herein is to select list, my lord, in respect of post of ophthalmic assistant, my lord, in the Director of Health Services, my lord. The advertisement, my lord, it came out in 2001. It prescribed a minimum eligibility that you should be of science background and having a diploma. The written examination was conducted, my lord, the petitioners had qualified. Subsequently, my lord, on 18th, when the written this year, 18th of April 2023, the results came out. Thereafter, there was a skill test and a document verification. The final results, my lord, came up on 10th of May 20.
According to you, ineligible candidates have been.
My lord, we had
You
spoken
have to name them and make them parties.
My lord.
I'll-
My lord, that I understand. That statement I have in fact made, my
No,
lord.
no, are they parties?
No, my lord. No, as of now, my lord, I have not been able to, because the time was so short.
Necessary.
Tomorrow, my lord, the appointments are going to come. The time was short. I have made statements that I have the names, 4 names I have, but then other particulars and details I don't have. So I have craved the liberty that, my lord, I,
Issue notice at this stage, that's all.
my lord.
Heard Mr. B. Pathak, Learned Counsel for the petitioner, peruse the amendments made in the writ petition. Mr. D. P. Bora, Learned Standing Counsel, Health and Family Welfare Department, Assam, submits that this writ petition is not maintainable in law as well as in the facts and circumstances of the case. First, the Learned Departmental Counsel therefore prays for some time to obtain instruction, file affidavit, issue notice returnable in 6 weeks. Since Mr. Bora has appeared and accepted notice,
All the
the
respondents.
respondents, no formal notice is required to be sent in this case. Extra copy will be furnished to the Learned Department Council.
My lord, the appointments may be, my lord. sir.
Hard on the prayer of interim relief, the said prayer stands rejected.
Obliged.
My lord, in this matter, my lord, Mr. Bikram Chaudhary is appearing, my lord. He is coming, my lord. If my lord is issuing only notice, then my lord, I can, otherwise.
What is the matter? Let's-
That is. Same thing, my lord. Recruitment,
All right, same order.
same order, my lord.
You have a prayer for interim relief?
Yes.
Yes, I am prayed for interim only, my lord. One post may be kept in vacant.
Heard Mr.
I on behalf of M. Mondal.
Huh?
Myself, M. Hussain, my lord, on behalf of M. Mondal, my lord.
M.U. Mondal, Learned Counsel for the petitioner, peruse the amendments made in the writ petition. Mr. R. Dhar, Learned
I will appear for one.
Departmental Counsel appearing for the respondent submits that this writ petition is not maintainable in facts and circumstances of the case. Stop. Therefore, there comes Mr. Chaudhary. Mr. B. Chaudhary. Therefore, he be granted 4 weeks time to obtain instruction and file affidavit. Would I allow? issue notice of motion returnable in 6 weeks. Since the respondents are duly represented by the learned department counsel, no formal notice is required to send in this case. Extra copies of the writ petition be furnished to the learned department counsel because they enable him to obtain instruction. How the prayer of interim relief, having regard to the facts and circumstances of the case, the prayer for interim order is hereby rejected. Same will be in the previous, having regard to the facts. Yes.
Lordship, may kindly pass over the matter for timing.
So may I please your lordship? So lordship, we approach this honorable court for the second time. Again, order was passed. That is in page number 20, your lordship. To consider our representation.
No, where is the representation? Page number?
It's in page number 20. Again, 20.
How many petitioners are there?
There are 37 petitions.
One representation filed by everyone.
Yes, sir.
Huh? What is the prayer? Let us see. Page number 37.
Page number 27, your lordship. In an order was passed to consider our representation. Your lordship.
What is your representation? I'm asking you. Where is the representation?
Your lordship, lordship,
Yes.
petitioner were home guard initially, then thereafter on 2012, they became SPO and 2016 or 17, they have been discharged, and meanwhile an order was passed that 1200 SPO are been terminated for their service. Then after that, we have filed a case on WBC 7479/22. In there, we have said that the new post should be made for them.
Who said that?
We have paid for that.
New post to be made. And that you have submitted a representation.
Yes, lordship.
And there is an order to consider that.
Yes,
representation.
yes, lordship.
See, how can on a representation new post be created? You show me your address argument on that. Can it be done? Creation of post, can it be done on the basis of representation? Then the whole country will come and say, create post to employ us. Is it permissible? In a court of law, law has some role also. Nowadays, law is shown in the backyard, but tell me what is the legal principle which permits that? Are you aware?
No.
Then you examine that, come prepared and then you argue. What is your name?
P. Chakraborty, lordship.
Mr. P. Chakraborty, learned counsel for the petitioner, who prays for posting this matter again after 10 days for motion, so as to enable him to examine the legal issues and address arguments before this court. Mr. R. Dhawan, learned government advocate Assam, is present on behalf of the respondent. You find out what is the law, what is the legal principle that 2017 terminated. Now can the court say that create posts on the basis of their representation. If you can show me a judgment, I will pass an order or some legal principle. Otherwise, I'll dismiss it on the next day. Correct? 10 days is enough time? Then you come to.
Hopefully, chalo.
May I please illustrate? In this case, the petition is dismissed for service
Hmm.
from the Cooperative Effect Agreement Limited, Your Lordship. And hence
What is the date of order of dismissal?
dated, Your Lordship, 18/11/2015.
Sure.
After that, there is a criminal proceeding was going on, and that criminal case judgment is still in favor of the petitioner.
We'll
acquitted.
issue rule at this stage, that's all. But Mr. S. Islam, Lord Counsel for the petitioner, assailing the order of dismissal for from service dated 18/11/2015. The petitioner, who was serving under the Assam Cooperative Apex Bank Limited, Panbazar, has approached this court by filing the instant writ petition. I have perused the averments made in the writ petition. Issue rule returnable in 8 weeks. Who is appearing for? You are appearing?
J. Borman, on behalf of J.K. Goswami, for respondent number 1, 2, and 3.
Mr. J.K. Goswami, learned.
I am J. Borman.
All right. Are you the standing counsel?
No,
Mr. J.K. Goswami is the standing counsel of
My lord.
Apex Bank.
my lord.
Then I'll record his name. Yes, Mr. J.K. Goswami, learned SC, Apex Bank Limited has appeared and accepted notice on behalf of respondent numbers 1, 2, and 3. And Mr. G. Bordoloi, learned standing counsel Corporation Department for respondent number 4. No formal notice is required to be sent in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the learned departmental counsel so as to enable them to obtain instruction. Since it is a case of dismissal from service, the learned departmental counsel to produce the records.
Yes.
May I please, Lordship? This is regarding my lord, height dispute, my lord. Your Lordship already disposed of some matters, my lord. One of the cases, my lord. Earlier height was 165, but now it is reduced, my lord. That cannot be, my lord.
So they'll file appeal.
Appeal, my lord.
Yes. How many petitioners?
One petition only.
अपना ये दो ऑप्शन है।
14. Putting same.
Disposed of.
14 also same, my lord.
Huh?
Item 14 also same, 14.
14 also same, one petitioner.
Yes, my lord, one petition.
14 also same.
Only say height and chest in that case, my
Huh?
lord. Height and chest, my lord.
It's in item 14, add the word chest also.
My lord.
Yes.
Obligation.
May I please, Your Lordship?
Same in item number 7. Same in item number 7, Lordships.
What is it? Height?
Lordship.
Height?
Height, there are 9 candidates in petition number, item number 8, 10 and 1000,
Petitioners.
8, 10 and 13, Lordship. There are total 9 candidates.
8, 10 and 13.
Yes, 8, 10 and 13.
Let's check whether it's petitioner or petitioners. Who is the CGC here? 8, 10 and 13 similar orders. Just check, it is all about height.
Yes, Lordship.
So same as that, as item 7. Yes, disposed of.
Let's.
Right, His Lordship. Your Lordship, this petition is filed afresh, impleading the private respondents, Lordship, but I could not annex the order that by liberty was granted to withdraw earlier petition, Lordship. The Lordship, 24 post of account officer was created in the PNRD department,
You have implemented the private response.
Lordship.
Then we'll have to issue notice now.
Lordship, this earlier graduation list was prepared.
Hmm.
And my position was 11, page 89, Lordship.
Hmm.
My position was 11. In order
Yes.
of seniority, it was prepared. And it is specifically stated there, if no objection is received within the stipulated time period, the seniorities so fixed in the combined graduation list will be treated as final. I am 11. Now, again, a gradation list is prepared. Now I have been brought down to 48. And this particular gradation list is prepared on the basis of date of birth, not on length of service. Page 94, Your Worship.
So all right, we'll issue notice and on both on main as well as interim prayer. Heard Mr. S. D. Kulkarni, I counsel for the petitioner. Where was the averments made in the writ petition? The petitioner is aggrieved by the decision of the authorities to prepare a fresh gradation list by downgrading him in order of seniority. Mr.
P. Handick.
P. Handick, Learned Standing Council, PNRD Department, Assam, prays for some time to obtain instruction in the matter. Issue notice of motion returnable on 21st of, no, returnable on 28 June 2023. Since Mr. Handick has appeared and accepted notice on behalf of respond numbers
1 and 2, my lord.
1 and 2 and Mr. 1 and 2, no formal notice is required to be sent to the said respondents. Extra copies of the writ petition be served upon the Learned Departmental Council. Petitioner to take steps for service of notice upon respond numbers 3 to
44.
44 by registered post with AD. Then let us have it after vacation. Your notice will not come back.
May I say one thing?
Then it
Lordship?
will go to August.
No, may I say one thing only, Lordship? The notice upon respondent number private 3 to 44 may be served through respondent number.
That cannot be the first order. First, you have to issue notice by registered post. What do you want? June? June, if
June.
there is no notice, it will go to September.
June,
August and-
I will take steps on today only, Lordship, June.
By registered post with AD. Hard on the prayer of interim relief. This said prayer will be considered on the returnable date.
Obviously.
Here the petitioners were all master roll workers engaged during 93, 94, 95, 96. And they were later on removed. Then after High Court order, they were again reinstated in 2000. And during the period they have been working. And the state government's policy was till 2013 of regularization of services as government employees. And that was done to about 30,000 employees of this category during that period. But subsequently, in against the 14 order of the Honorable High Court, where series of writ petitions were allowed and directed government to regularize their services. Considering the length of service as master roll workers, the state came in appeal. And in appeal of 14,
So
45
petitioner,
or 14.
petitioners have retired from service.
No, they are only one retired. Others are in service.
So retired and serving have come together.
No, during the period when they approached the Honorable Supreme Court,
Hmm.
in writ, they are,
No, Mr. Sachalia, you want pension
My
after retirement. One can understand a retired person coming and asking for it. But how can a serving person come in together?
since the, after the 14th, 17th order of the Honorable High Court,
Hmm.
by the state government has denied the pension to these employees. So
Right,
they
we'll
approached the,
We'll issue notice
My
at
lord,
this
my
stage.
lord.
Heard Mr. D.P. Cholila, Senior Counsel, assisted by Ms. M. Royal and Counsel appearing for the writ petitioner. The petitioners herein are seeking a direct, petitioners herein were all initially engaged as master role stroke work charge employees under the different engineering departments of Assam. Full stop. Subsequently, their services were continued on the master role stroke. Aggrieved by the decision of the respondents not to pay minimum pension after their retirement, the petitioners have approached this court by filing this writ petition seeking a writ of mandamus. Full stop. Mr. N. Upadhyay, Learned Standing Council, Irrigation Department, Assam, and Mr. A. Chalia, Learned Standing Council, Finance Department, Assam, have prayed for some time to obtain instruction in the matter. Issue notice of motion returnable in 6 weeks. Since Mr. D. Bora, Learned Government Advocate, Assam, has accepted notice for respond number 1, Mr. A. Chalia for respond number 2, and Mr. N. Upadhyay.
3 to 9,
for
Lords.
numbers 3 to 9.
Yes.
Service of notice is deemed to be complete in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the learned departmental council so as to enable them to obtain instruction and file affidavit. Let them file affidavit.
Obliged, Lords.
But here the petitioner had applied for recruitment in the CAPF and the height problem is that if Lordship will kindly have page 50.
Is it same matter?
My lord, it is not that. That is what I'm trying to point out. Page 58, my lord. Page 58. Lordship will find the candidate's copy. The height part, the first row, my lord, says general SC OBC, my height is recorded as 165. It should have been recorded under the 4th row, my lord, the minimum height of candidates falling in categories of Garhwali, Kumaoni, Dogra, Maratha, and candidates belonging to state of Assam. Instead of considering me to be a candidate from state of Assam, they considered me under a general category. In the 4th row, my lord, 165 is the minimum height required. I have the minimum 165, and yet on the next page, my lord, I was rejected saying that my height is 165.
Here also you have to prefer an appeal. We'll ask them to
My
pass.
height is already there, whatever they require.
What do you want the court to do? Give you an appointment order?
Yes, my lord.
Heard Mr. R. Majumdar, Learned Counsel appearing for the petitioners, peruse the averments made in the writ petition. According to the petitioner, documents on record indicates that he meets the minimum height requirement of 165 centimeter. However, on an erroneous recording of data in the inappropriate column, the petitioner has been rejected for not meeting the height requirement
Of 170 centimeter.
of 170
170
centimeter. Full stop. Mr. Majumdar submits that what is it? 170 is for whom?
For all the rest of India, for state of Assam, it is 165.
Mr. Majumdar submits that the petitioner belongs to the state of Assam, and for this region, the minimum height requirement is 165 cm. Full stop. The requirement of 170 cm is for the rest of India, which is not applicable in case of the petitioner. Full stop. Mr. A.K. Datta, Learned CGC, appearing on behalf of the respondent, submits that the issue can be adequately addressed if the petitioner prefers an appeal before the competent authority by annexing the relevant documents. Mr. Majumdar has also agreed to such a recourse. Stop. In view of the above, this writ petition stands disposed of at the stage of motion hearing by granting a week's time to the petitioner to prefer an appeal before
It will go before.
before the appellate authority. That is,
Before, okay, two, my lord, respond number two.
if you give a wrong indication here, you are gone, finished.
I think.
Yes.
It will be the respondent.
Who is the appellate authority? Before the competent appellate authority. If such an appeal is preferred within 7 days from today by enclosing a certified copy of his order, the same be considered on merit and disposed of by a reasoned order after verifying the records. Full stop. The aforesaid exercise be carried out as expeditiously as possible, but not later than 45 days from the date of receipt of the record, or 30 days from the date of receipt of record. Until such time the exercise is completed, one post of constable stroke constable bracket GD in the CAPF
Recruitment board.
comma SSF comma Assam Rifles the present recruitment process be kept vacant. Writ petition stands disposed of.
In the writ petition, they have not named the appellate authority, they have simply said appellate.
I've also kept it open. Any other? You have more matters like this today? Only one.
Only one.
What happened to the others?
Well, the other two were there, my friend appeared.
And some are also being filed. Where do you get so many cases of this nature from?
The word spreads,
Huh?
word spreads.
You should share the information with others. See, everybody is looking every day. Mr. Majumdar comes with bunch of similar orders. Yes,
They get the, they get the name
some
in the
secret,
order.
trade secret. Alright. But all the best.
20 years,
Yes.
21 years, my lord, CRPF, so
Okay.
the name is there.
Obliged.
May I lordship. But the matter is let you know, less than 3 years in service matter, it was rejected matter, not compassionate ground matter.
Yes, these matters have to go back. Take down heard Mr. A. Khanikar and his counsel appearing for the petition. Full stop. After the demise premature death of the petitioner's husband, a petitioner's father, he had submitted an application seeking appointment on compassionate ground. Full stop. However, the said application was rejected by the SLC by the decision recorded in the minutes of meeting dated 23/12/2019 on the ground that the father of the petitioner had less than 3 years of service left left to his credit at the time of his death. Full stop. The aforesaid stand was taken by the SLC based on clause 1 of the office memorandum dated 01/06/2015. Mr. Khanikar, however, submits that clause 1 of the OM dated 01/06/2015 has been set aside by this court by judgment and order dated 30/1/2023, passed in connection with writ petition number
1208 matter,
1208 of
23. No, 1646.
1646.
1646,
1646 of
21.
2021. Therefore, the ground on which the petitioner's application was rejected calls for reconsideration. Ms. S. Sharma, Learned Standing Council, Health and Family Welfare Department, Assam, PWD Assam, appearing for respondent number 4, and Mr. D. Bora, Learned Government Advocate, Assam,
2 and 3.
appearing for respondent numbers 2 and 3, submits that although an appeal has been preferred by the state against the judgment and order dated 30/1/2023, yet the appeal has not yet been admitted, nor is there any stay order operating therein. Full stop. If that be so, this court is left with no option but to remand the matter for reconsideration by the SLC on the merit of the application submitted by the applicant. Dehors clause 1 of OM dated 1/6/2015. In the minutes of the meeting of SLC dated 23/12/2019, qua the petitioner is accordingly set aside and the matter is remanded back for fresh consideration of the application submitted by the petitioner for appointment on compassionate ground by the SLC. With petitioner is responsible.
May it please the lordship. Lordship, we are challenging the order of dismissal from service, lordship.
Where is the order?
Lordship, the order by the appellate authority is at page 136, lordship, starts at 136. By this order, the order of the disciplinary authority has been upheld relating to removal from service, lordship.
What is the ground of challenge?
Lordship, the ground of challenge is that the provisions of the Assam Service Discipline Appeal rules have not been followed in the instant case. Lordship, during the entire proceeding has been conducted ex parte against the petitioner. The list of witnesses was never provided. He was never given any opportunity to appoint a defense representative. And lordship, further, the inquiry officer has gone to make some finding against him for which no charges have been framed.
What is the date of order of removal from service?
Lordship, that is dated nil, lordship. We do not have the date, lordship.
How can it be? Where is the order?
Lordship. Lordship will find that at page 87, lordship. Lordship, the effective portion is at page 92.
Undated order of dismissal, removal from service.
Lordship.
Mr. Bora,
Your lordship, let me seek instructions.
let him obtain instruction.
Lordship, in fact, this is the third round of litigation. Earlier, we had challenged the appellate authority's power to take up the matter. At that point of time, also the same order was annexed, no affidavits filed. Ultimately, they submitted the inquiry, the appellate authority was changed. Now the new appellate authority comes in and without.
All right, heard Mr. M. Das, learned counsel for the petitioner, assailing the undated order issued by the disciplinary authority, imposing the penalty of removal from service, as well as the subsequent order of the appellate authority affirming the penalty. The instant writ petition has been filed, inter alia alleging that the respondents have acted in utter violation of the provisions of Assam Service (Discipline and Appeal) rules, 1964, in imposing the penalty upon the petitioner. Mr. D. Bora, learned government advocate, Assam, prays for some time to obtain instruction and file affidavit. In view of the above, issue notice of motion returnable in 6 weeks. Since Mr. Bora has appeared and accepted notice for the respondent numbers 1, 2, 3, and 4. No formal notice is required to be sent in this case to the same respondents. Extra copies of the writ petition be furnished to the learned departmental counsel within a week from today, so as to enable him to obtain instruction and file affidavits. Having regard to the facts and circumstances of the case, this court is not inclined to issue notice to respondent number 5 at this stage, and the matter will be considered at an appropriate stage as and when necessary.
In fact, respondent number 5 was not required because though we have made some allegation against him, but that pertains to the earlier appellate authority's power which he had exercised at that
Then
point of
let
time.
us,
Lordship, let it remain because there are some avertment against him.
he is not inclined to issue notice for the respondent number 5 at this stage.
Lordship. Obliged, Lord.
Item 17.
May it please your lordship. Yes. The petitioners are erstwhile employees of the HPC at Kachar Paper Mills. And when the paper mills closed down in 2015, the government of Assam had an agreement with their unions that these are some of the employees who are eligible will be absorbed as employees of the government of Assam. And these 3 petitioners who have come before lordship have on the basis of those agreement have been appointed. But the only issue as of here is that they were supposed to be appointed as per their qualifications in the agreement, but these persons who were otherwise eligible to be appointed as grade 3 have been appointed at grade 4. So they have come, they have made some applications as well as the union have made application to upgrade that and review the orders, but that was not done. Therefore, they have come before this honorable court. To
Upgrade them from grade 4 to grade 3 post.
grade 3. They were otherwise as per the your lordship agreement that page 26, lordship will see. Between the Government of Assam and the Hindustan Association of Hindustan Paper Corporation, lordship will turn up to page 27. Specific parties at.
So we
para-
issue notice at this stage.
Yes, but only issue is that these, if the post of grade 3 are filled out, then there may not be there may be a difficulty if your lordship here.
No,
finds it-
any move going on to fill up?
There is actually, there is a move to fill up about 40,000, 50,000 posts.
That is day after tomorrow.
Yes.
That will not stop.
No, that we are not going to, but in this case, I'm saying, there are 100 posts where they wanted to fill up,
You-
66 have been done.
If any move is there, you will consider, will issue notice
Yes.
on the interim also.
Yes.
Heard Mr. Y.S. Manal, counsel appearing with the petitioner. The read petitioner's hearing. Where employees of erstwhile Hindustan Paper Corporation Limited, subsequently, they were
No,
absor-
Kachar paper mill.
Kachar,
Hindustan paper mill, we have two. So this is with
Kachar
regard to
Paper
Kachar
Mill
paper.
Limited, Pachgram, Hailakandi. They are still in Pachgram. No,
No,
Pachgram
no,
is
they are
not-
now absorbed. They have already been appointed by this, by
Subsequently-
the appointment letters I have given
The
you.
petitioners have been absorbed under the Department of Industries. They have been absorbed where?
They have been absorbed, your lordship, in three different
In three different departments.
departments.
In the, under the government of Assam.
Yes.
According to the petitioners, although they were entitled to be appointed against grade 3
Three
posts,
posts.
yet the petitioners were actually offered grade 4 post in which they are serving
As of now,
as on date.
yes.
Aggrieved by non-consideration of their prayer for upgradation into grade 3 post. The petitioners have approached this court by filing the instant writ petition. You are appearing for whom?
Kalita.
Acha, Mr. A. Kalita, Learned Standing Council, Industries Department, Assam.
Lordship 1, 2 and 8.
As well as Mr. D. Boral, and Government Advocate Assam have prayed for some time to obtain instruction in the matter. Issue notice of motion returnable in 6 weeks. Since Mr. Bora has appeared and accepted notice for report number
7.
only respond number 7. And Mr. Kalita for respond numbers
1, 2, 8.
1, 2, 8. No formal note, 1, 2, and 8. Mr. Kalita is appearing for Deputy Commissioner also.
No, he is appearing for deputy commissioner.
I'm appearing for.
7, he is appearing.
Mr. Bora for 8, Mr. Kalita
And
for
also
Eight.
four yellow.
1, 2 and 8.
1, 2, and 9.
8.
8 is Deputy Commissioner Hailakandi, Mr. Manan.
8 deputy commissioner.
You made a,
In General Manager, District Industry and Commerce Center.
you correct it, then we pass on. Check it.
Even 8 is a deputy commissioner.
You give a slip who you are appearing for after consultation. No formal notice is required to be sent in this case to the said respondents. Extra copies of the writ petition requisite in numbers be however submitted. However, furnished to the Learned Department Council. Petitioners to take steps for service or notice upon the remaining respondents by registered post with AD within a week from today. Hard on the prayer of interim relief, the said prayer will be considered on the returnable date. Mr. Manan, please,
Yeah, I've asked
there are a
him.
lot of mistakes with the writ petition.
Correct,
That's why they are confused. Yes.
Obliged.
Marks on this. Just take it in who is appearing. Yes,
May I please, Your Lordship?
yes, please.
It's a matter pertaining to non-issuance of release order, Your Lordship.
Sorry,
Release order to the petitioner,
release order.
Lordship.
Lordship, in this matter, can the matter be taken on Wednesday? I'll come up with written instruction whether the release order has been issued or not on Wednesday, Your Lordship. I'll come up with the instruction.
Lordship.
All right. Mr. R. Borolani, counsel for the petitioner.
peruse the averments made in the writ petition. Mr. R. Gogoi, learned SC Forest, seeks posting of this matter for motion again on next Wednesday, give the date. 31st
31st.
of May 2023, so as to enable him to come up with specific instruction as to whether release order has been issued to the petitioner, and if not, the reason thereof.
Yeah.
One extra copy of the writ petition be furnished to Mr. Gogoi. Let this matter be listed accordingly.
In fact, 19 is also same, your lordship,
Same order,
on Wednesday.
Oblige.
Oblige, lordship.
along with 18.
May please, Lordship. This is regarding Constable GD, my lord. Similar order is there by page 61, my lord. Your Lordship's order is there, my lord. Covered case, my lord.
Similar order as in page 61, council's name you have to
My
change.
lord, yes.
How many petitioner?
One petitioner, my lord.
Yes, page 61 is the order, no, disposed of.
Oblige.
I'm being letter item 4.
My lord, another code, my lord. I have still. Oblige, my lord.
Supplementary list for motion item 51.
May please, my lord.
Yes,
Lordship, yesterday, my lord, I was supposed to go through the rule, my lord. In the rule, my lord, what they have stated in the affidavit, my lord. Prior to the rule, my lord, kindly peruse the affidavit filed by the respondent, my lord. First, paragraph 6, in respect of, in response to my paragraph 5 of the writ petition, my lord. In Seva portal, accordingly, I'm reading, lordship.
yes.
That with regard to the statement made in the paragraph 5 of the writ petition, the deponent begs to state that the state level recruitment commission for class 4 post has declared the result through two web portal, namely official website of the government of Assam and Seva portal, through which the candidates who had appeared for the interview can assess their respective results in the secure and convenient manner. Accordingly, and when assess the candidate, the final outcome status of their interview is declared in the portal, my lord. In this paragraph, my lord, nothing has been mentioned regarding the publishing of any merit list, my lord, or select list, my lord. And then, my lord, turn to page 51, my lord. Paragraph 7, I am reading the 51, page 51, the middle paragraph, my lord, from the bottom two.
from the bottom two, the comparative merit list of the provisionally selected candidates, candidate is for determination of the grade pay according to their merit or rank and has no bearing in the declaration of the overall result of qualified successful candidate or appointment into the grade 4. This is according to this statement, my lord, only to ascertain the grade pay, the merit list is required. I'm coming to the rule, my lord, what rule says. And then, my lord, kindly turn to page 53. In the bottom two, my lord. The commission in its communication for recommending the list of provisionally selected candidates to the senior most secretaries of the department by letter number so-and-so dated 4/5/2023 have instructed the department as the appointing authority to verify the maximum education qualification of the recommended candidates before the issuance of the appointment, my lord. Here also nothing has been mentioned regarding the merit list. Now they have annexed and one documents, my lord. This is the letter. This is the format of the letter, my lord. At page 64, Annexure D, my lord. This letter has been forwarded by the commissioner of the state commission, my lord. Now, my lord. My lord, now, my lord, kindly take the rule, my lord. The rule, the Assam Direct Recruitment for the class 3 and class 4 analogous post rules 2022, my lord. In the rule, my lord, lordship will find rule 11 sub rule 2, my lord. The commission shall select the candidates for the recommendation for merit in order to higher grade pay, taking into consideration reservation for scheduled castes, scheduled tribes, more other backward classes and other categories, not only for the grade pay, my lord. Merit list. So And- are the petitioners belonging to the reserve category candidates? Yes, my lord, all are, except the first is the women category and others are the another category. And now, my lord, kindly turn to page, next page, my lord. Paragraph 12, rule 12, 2. In next page, my lord. Next
Yes.
page, my lord. Rule 12(2).
Yes.
The merit list shall be published under the signature of the chairman and all other members and commission, and a copy of the list signed by all of them shall be forwarded to the respective department for appointment.
Correct.
Here nothing has been done, my lord. No merit list has been.
Mr. Borua, I see your case is that twofold. First, that ineligible candidates have been admitted in the process and they are likely to be appointed. But that there is no facts, no particulars about that. This is just a bold allegation. Second, you are saying that there is no merit list published.
Yes, no
But you
select list,
don't-
not only merit, select list.
Will you have the patience to listen, please?
So-
But it is a fact that all of you are unsuccessful candidates.
Yes, Lord.
You have checked your results through the online portal, through your, and you have, it has turned out that you have not qualified.
Yes, Lord.
But your question is, even if I am not qualified, who else is qualified? I want to know. Because they are bound to publish a merit list.
Yes, ma'am.
They are saying this entire process has been done as per provisions of this rule, and which provides that a merit list will be published only for the purpose of deciding the grade pay. Grade pay
And reserve candidate.
and reserve category candidates. To the extent that what is this benefit to be given to a selected candidate based on his or her reservation status, meaning roster point,
Yes, Lord.
correct?
Yes, Lord.
Now, if you are not selected, you have not assailed that, you are accepting that you are not selected.
Yes, ma'am.
Then at your instance, you want the court to stall the entire appointment process. What for? Is it a reasonable prayer before the court? You are not even saying that you should have been selected. That's not your case.
Yes.
Then why are you wasting the court's time? If you are not selected, you have accepted it. Why should we go into all this aspect of the matter, particularly when the action taken by them prima facie is in accordance with the rules? You are not challenging the rule. That is the same question the court asked you yesterday.
instead of answering that, so will you please take your seat and let me dictate the order? You are unsuccessful candidates.
Yes, Lord.
You don't question your non-selection. But you want to know who else has been selected,
Because
how they have been selected.
because
That is a PIL. Go and move a PIL. Heard Mr. D. Borwal, Learned Council appearing for the. Yes, you want to say anything, Mr.?
No, Lordship, and if he can
Mr.
pinpoint anybody who is well overqualified, we are welcoming his.
Give him liberty.
Yes,
you
Lordship, he
find
can
it-
always come and we'll be more than happy to find out those.
If there is any
persons.
anomaly in the
Yes,
process.
yes,
then
we are with the petitioner here.
You ask for information through RTI. Why have you come to the High Court just for getting information?
No, my lord, actually what happened, my lord, without publishing the merit list, my lord, they are going to.
Oh,
Yeah, yes,
publishing the merit, you are not successful.
Yes, yes, Lord.
So you ask for a merit list, RTI or whatever information you want. Why have you come to the read court for this? Heard Mr. D. Borwal, Learned Council appearing for the petitioner. Also heard Mr. D. Saikia, Learned Advocate General Assam, assisted by Mr. B. Chaudhary appearing for the respondents. First up, the read petitioners hearing numbering 8 in total had participated in the recruitment drive initiated by the state of Assam through the state level recruitment commission for filling up number of vacancies in the class 4 category of posts. Full stop. On conclusion of the recruitment process, the candidates were asked to check their results through online portal by furnishing their roll numbers. Full stop. It is the admitted case of the petitioners that on verifying their results, none of the petitioners were found to have been qualified in the recruitment process. In other words, the petitioners herein are unsuccessful candidates. First of, notwithstanding the same, the petitioners have approached this court while filing the present writ petition, assailing the selection process inter alia on 2 grounds. Firstly, that ineligible candidates have been admitted into the recruitment process and are now going to be appointed in grade 4 post. First up. Secondly, by not publishing the overall merit list, the respondents have held back relevant information from the participants. First up. It is the case of the petitioners that candidates who were graduates have been selected for appointment in various departments. First up, by relying upon a decision of the Supreme Court rendered in the case of State of Bihar versus Kushal Kishore Singh and others, reported in 1997.
1998. 1998 HCC 104.
1998 8 SCC
104.
104. 1998 9 SCC 104. Mr. Borua, Learned Counsel for the petitioner, has argued that it is mandatory for the department to publish merit list. Therefore, now, by not publishing the merit list, the respondent has conducted the selection process in a completely non-transparent manner. Full stop. The respondents have filed affidavit controverting the stand of the petitioner. According to the respondents, the selection process was carried out as per the provisions of Assam Direct Recruitment for Class 3 and Class 4, Roman 3 and Roman 4, analogous post rules, 2022, which does not mandate publishing of merit list, save and except for the limited purpose of determining the grade pay of the recruited candidate, and also for consideration of reservation for scheduled caste, scheduled tribe, and other more other backward classes candidates. Full stop. Full stop. Under the circumstances, the there was no obligation for the state to publish a general merit list in this case. First of Mr. Saikia Lanet, Advocate General Assam, has also argued that if any candidate who was not qualified and duly selected in merit is sought to be appointed in this process, then the state would itself come in the way and not permit any such appointment. However, in the process of in the absence of any particulars of such anomaly having been furnished in the writ petition, there is no ground for this court to entertain the writ petition. Full stop. Insofar as the allegation of admitting ineligible candidate is concerned, I find from the pleadings that no particulars of any such candidate has either been furnished, nor has any such person been implicated as a respondent in this process, in this writ petition. Therefore, the aforesaid allegation on the face of it appears to be bald, and therefore, and hence does not merit consideration by this court. Insofar as the second allegation is concerned, here also I find that the process adopted by the respondents prima facie appears to be in consonance with the requirement of the rules of 2022. Full stop. The said rules are not under challenge. If that be so, the writ petition cannot also be entertained on the second ground urged by the petitioners. As a matter of fact, in view of the specific provisions contained in the rules of 2022, the decision rendered in the case of Kushal Kishore Singh and others bracket Supra relied upon by the petitioners' counsel would also have no application in the facts and circumstances of this case. Situated thus, this court is of the opinion that there is no good ground to entertain the petition at this stage. However, the petitioners will be at liberty to seek relevant information about anomaly, if any, in the selection process, or selection process by taking recourse to the provisions of RTI Act 2005. On receipt of such information, if any ground exists for assailing the selection process, it will be open for them to approach this court once again. With the above observation, this writ petition stands disposed of.
Highly obliged.
The petitioner, in response to the advertisement issued by the district judge Borbata, has applied for the post of contextual peon. The application has called for 2 regular peon, 1 contextual peon money. 2 separate lists of the candidates are also published, and he has applied for the post regular and the contextual. And after selection, the one Ryan Das was appointed in the contextual post, though he has not applied for the contextual post.
What is the matter, Mr.
No, I just fail to understand what the petitioner is saying. He wants to select list. My lord, if your lordships kindly turn to page
We'll
30.
issue notice.
There's nothing in the
That will help us
absolute
understand what he wants. Heard Mr. K. Sharma, learned counsel for the petitioner, peruse the averments made in the writ petition. Issue notice returnable in 6 weeks. Since Ms. A. Talukdar, learned government advocate Assam has appeared and accepted notice on behalf of respond numbers. On behalf of respond number 1, you are appearing for 2, is it?
I am for 2.
And Mr. H. Das Lanet SC GHC for respond number 2. No formal notice is required to be sent to the said respondents. Extra copy of the writ petition will be furnished to the learned department counsel. Yes, to enable them to obtain instruction. A petitioner to take steps for service of notice upon respond numbers 2, 3 and 4.
But
we
pay for interim also.
Hard on the prayer of interim relief, the said prayer will be considered on the returnable date.
Highly obliged.
6 weeks.
Lordship, may I adjourn the matter for the time being, Lordship? My senior is on late, Lordship.
No, what is the matter? Let us see.
My lord, I am challenging the selection of the respondent number 6, my lord, as against the post of Gao Pradhan. On the ground that, my lord, he is not eligible.
Appeal.
Appeal is pending, my lord,
Let the appeal be disposed of.
my lord.
That's all.
Lordship,
the appeal be
writ-
disposed of.
the writ petition has been filed in writ of quorum to Lordship. In this case, the writ of quorum is not lie, Lordship.
Watch that matter.
Lordship,
Let him come. Timely.
obliged, Lordship.
Yes.
May I please, your Lordship? Lordship, I have challenged this writ petition, a final impugn final list, Lordship, for the post of 26 MBA Inspector, Lordship, under APC Department, Lordship. Now, Lordship, the final list is at page number, Lordship. 29, Lordship. Lordship, there are 26 candidates, Lordship, who got selected in the final list, but my name is not there, Lordship. I am not the selected candidates. Now, Lordship, my main grievance to file this writ petition, Lordship, at page number, Lordship, 38, that is the RTI reply, Lordship, which shows, Lordship, that the whole recruitment process is erroneous, Lordship, and which shows that, Lordship, I am the highest marked holder, Lordship, of the under the EWS category, Lordship. But before going to that aspect, Lordship, some connected matters are pending before this honorable court, Lordship, which I need to apprise, Lordship. Lordship, as per the
Yes,
advertisement,
you have apprised. What is the corrected matter?
Lordship, I have received instruction, my lord, the appointment order is not under challenge in this writ petition. Lordship, I have motive.
Yes, yes.
Yes, the appointment order has been issued on 19/5/2023, and this petition, this order is not under challenge. This is my submission. my lord.
Lordship, this honorable, before I have already stated, Lordship, that the issue is before this honorable court, the connected meters. Lordship, some of the candidates who are not having 3 years diploma in mechanical engineering, Lordship, are before this honorable court. There are 6 candidates, Lordship, who are petitioners in WPC 4281/2023, Lordship. Now, Lordship, the concerned advertisement required education qualification specifying that the candidate need to be 3 years diploma holder on automobile or mechanical engineering, Lordship. And I am the diploma holder, Lordship. Now, those 6 candidates in 4281, Lordship, they are the bachelors in engineering without having a 3 years diploma, Lordship. And in that matter, Lordship, on 26, Lordship, those candidates are allowed to participate in the process, Lordship, without having the 3 years diploma, Lordship. After that, Lordship may kindly come to page number 19, Lordship. Order dated 26/6/2022, Lordship.
Yes. Yes, please.
The relevant portion is as page number 20, Lordship, and paragraph 20, Lordship, paragraph 7, Lordship. In the interim, it is provided that the respondent shall allow the petitioners to submit their application forms and may also process the same and allow the petitioners to participate, but the final results thereof shall not be declared till the next attainable date. After that, what happened, Lordship, the APSC department represented by Commissioner, Lordship, filed an IA, that is IA 441, Lordship, 2023, Lordship, to modify this order, Lordship, to declare their final result, Lordship.
Yes.
And the earlier order, that is this order, Lordship, was modified. That is at page number, Lordship.
Page number 34, my lord.
Yes, yes.
Page number 27, Lordship. That is 12/4/2023, Lordship. This relevant portion I'm reading, Lordship.
Yes.
After hearing the submission of the learned counsel for both the sides, the APSC is permitted to declare the final result of the selection process, but no order of appointment based on the final selection list shall be issued till the next date, Lordship. Now, Lordship, this order is again modified, Lordship. Which is at page number, Lordship.
We'll issue notice and list it along with the other
My
matter.
Lordship, the appointment, Lordship, tomorrow, Lordship, the appointment letter will be
Already issued.
4 posts already issued. That's what.
On 19/5.
But
I have
22nd postal, Lordship.
No, already issued.
Red Hat, Ms. G. Boral, counsel for the petitioner, peruse the amendments made in the writ petition. The challenge in this writ petition is directed towards the process for selection and appointment of 22 MVS selection and appointment to be made in respect of 22 vacant posts of MVS. According to the petitioner, although he was eligible to participate in the selection process and get appointed, he has not been selected. Hence his writ petition. Ms. Bora Learned, Ms.
Standing
M.P. Bora Learned Standing Council,
Transport Department.
Transport Department, Assam submits that the order of appointment has already been issued on
19/5.
19/5/2023 in respect of the 22 selected candidates, but the said order is not under challenge in this proceeding. As such, the writ petition is not maintainable in law as well as in facts. Be that as it may, having regard to the grounds projected in the petition and considering the fact that another writ petition raising issue of similar nature being WPC number
4281.
4281 of 2022 is pending before this court. This matter would call for further examination. NOM 4 weeks since Ms. Bora has appeared and accepted notice for respond numbers
1 and 2.
1 and 2 and Mr. PP Datta Lanet APC Standing Council APSC for respond numbers 3, 4 and there is no 3 here. 3, 4 and 5. Bracket you write RNS 3 indicated as 4, 6 and 7 in the
Yes.
repetition bracket. In the service of notice is deemed to be complete in this case. Extra copies of the writ petition be furnished to the Learned Departmental Council. Registered to list this matter along with WPC number
4281/2022. Deeply obliged.
No, this is a matter regarding a transfer of the petitioner, madam. The petitioner is taking retroviral treatment in Guwahati, and she has been transferred, my lord, to Bangalore. And she is serving as a helper to a.
Where is the order of transfer?
The order of transfer, lordship, put on this page 19, my lord. The type copy, lordship.
Where is
find
the
it is-
CGC?
Perhaps since it was passed away in the morning, my lord, you might be in another boat.
Not allotted to me, so I'm not
Can
authorized.
you find out
Lordship.
I have filed an appeal also.
at 12? At 12?
Oh, yes. My pleasure.
Yes. Please find out. At 12, if nobody comes, I will record and pass an order.
Order stay vacating item 21.
The issue, I don't. The issue involved in this case is the BRS granted to the writ petitioner was as per rule 56C or not. That's the only issue. The Lordship will find in this case that in the imperial order, Lordship will find that with the approved treasury officer, he issued
This
that order.
IA has been filed for vacating stay order.
Yes.
Where is the order of the court?
This
Page number?
Lordship with the stay order, page number 11, my lord. IA, page number 11. My appointing authority is the deputy commissioner, but the treasury officer has passed this order. And your lordship knows, my lord, notice 3 months notice is required. And by forcefully sign was obtained from me, my statement is forcefully in the office, they came, took my signature. Being a widow lady, my lord, no way I was there. They took my signature. Next day, immediately I wrote to the treasury officer, what happened in that office next day. And before completion of 3 months, my lord, treasury officer issued the MP order saying that has been approved. No memo number, nothing was there, my lord. So lordship will, my lord, whether lordship will hear this or I feel in that sense of other party also, my lord. I don't feel like doing the cases.
Next week then.
Next week, my lord.
Heard Mr. Amnath Lalit, Senior Counsel, appearing for the applicant. None has appeared for the opposite party writ petitioner. Since in view of the prayer made in the IA, this court is not inclined to hear the matter in the absence of opposite party. Let this matter be listed again in the next week.
I appear for the writ petitioner in the matter, seeking a week's time matter to file my affidavit in opposition to the IA and my affidavit in reply to the affidavit in opposition filing the writ. The entire matter perhaps can be heard of in this post of.
This is the vacating application of the interim order, Lordship.
What is the interim order?
Lordship, Annexure B, page 17. Relevant portion, Lordship.
Page 20,
Page
madam,
20, last
paragraph.
paragraph. He was asked to appear before the inquiry. That was subsequently that order was there. This is the initiation of the board of inquiry, Lordship. So this
So
is.
why it has been stayed now?
Madam, there are there's already a court of inquiry held in the same year in 2020, which report I have annexed to the writ petition, which says that this misappropriation had not taken place. Every record was correct and it was done after my transfer out of the state place, and I did not participate in that court of inquiry, yet it held me to be innocent. Now, my lord, after 2 years on the same anonymous complaint, despite the directions of the CVO and the respondent authorities themselves that no action is required to be taken on an anonymous complaint, this complaint, they have started a de novo proceeding. De novo proceeding, my lord, in their application itself, I'll show, they have stated that the incident that has to be inquired is of 14/2/2022. In the entire case, my lord, they are investigating a matter of 2020, whereas there is no clarification that 2022 has to be read as 2020. I'll just file an affidavit, my lord.
Sharma, Learned Counsel is present on behalf of the applicant. Mr. R. Mohinder prays for a week's time to bring his objection on record opposing the prayer made in the IA. In view of the above, register to list this case again after 2 weeks, along with the objection, if any, filed by the opposite party writ petitioner. Interim order passed earlier to continue till then.
Obliged.
Order no steps, second 20.
May it please your lordship, 1 week time may be kindly granted for
Yes,
taking.
we thus Learned Counsel for the petitioner prays for and granted 1 week's time to take steps for service of notice upon the respondent as per the order of this court.
Lordship A. Kalita.
Mr. A.
On
Kalita
industry.
is present on behalf of the respondent, stroke industry department. List the matter accordingly.
Obliged.
So why should this be the orders matter steps? You will not keep it as part heard. This matter shall not be treated as part heard before this court henceforth.
Item 24.
Implement of the party respondent present incumbent lordship. Earlier incumbent already retired 1 and 2 lordship, but 3 already transferred from his post lordship.
Heard Mr. A.B.T. Hawk, Learned Counsel for the applicant, peruse the statements made in the IA. Full stop. This interlocutory application has been filed with a prayer to implead the opposite party numbers 1, 2, and 3 as respondent numbers 5, 6, and 7 in the connected contempt case on the ground that these officers are the present incumbent in the office which would be responsible for implementation of the court's order. Taking note of this stand taking note of the statements made in the application and in view of the submission made by Mr. Hawk, the prayer stands allowed. The opposite party stroke respondent numbers 1, 2, and 3 are hereby impleaded as respondent numbers 5, 6, and 7 in the connected contempt case. Office to carry out necessary correction in the cross title and list the matter after 3 weeks. IA stands disposed of.
Obliged.
For admission, item 25.
Yeah, my lord, the respond number 6 and 7, my lord, they have filed their affidavit, my lord. I mean, we have to do it.
All right, Mr. S. Islam Learned Counsel for the petitioner prays for and is granted 3 weeks' time to file rejoinder in response to the counter affidavit filed by respond numbers
6 and 7.
6 and 7.
Earlier also, my lord, they took stand about 1 year's back.
It is made clear that no further time will be granted to the petitioner for filing rejoinder. Who is for whom this,
I'm for respondent number 7,
Ms.
A Bora.
Learned Counsel is present for respond number 7 and Mr.
For 6.
So and so for respond number 6. Mr. D. Bora, Learned Government Advocate Assam is present for the state.
Item 26.
May I please, Lordship? Praying for adjourned the matter for today as because senior counsel is
As paid for by petitioner's counsel, admission hearing of this matter stands adjourned for 2 weeks.
published.
Item 27.
None appears for the writ petitioners when this matter is called up. Admission or hearing of this case stands adjourned for 4 weeks.
Item 28.
Lordship, till date, they have not served us any extra copy, so
No, today for instruction, my lord.
I am appearing for respond numbers
Oh,
3, 4 and
I
5.
don't know why.
Till date, we have not received any extra copy, so we could not send it.
Instruction, well, I am told that the instruction has been sent to them. But let
What
him
is
be
this
seen.
matter? What is the matter about? What is the issue here?
The appointment of the Anganwadi worker, my lord. The concerned Anganwadi worker resigned and thereafter, my lord, he is aspiring, my lord. But instead of his appointing her, somebody else has been appointed. And that appointment was made without approval of the joint director. And joint director also wrote a letter why you have allowed to join. Thereafter, my lord, this court also directed the concerned advocate.
Yes,
to have some
you are appearing.
Yes, your lordship, I am appearing for BTC, your lordship.
copy with her.
Your lordship, extra copy has not been served upon us, your lordship.
You please give them copies today itself.
Extra copy.
Heard Mr. A. Das Gupta, Learned Senior Counsel assisted by Ms. B. Das. Also heard Mr. D. Bora, Learned Government Advocate Assam, as well as Ms. P. Das, Learned SC BTC, appearing for the official respondents who submit that due to want of extra copies of the writ petition, instructions could not be.
No, I'm sorry, can copy it.
The Learned Departmental Council have been.
He's demanding 2 copy. I can provide 1 copy.
They respond, 3 response.
3 responding is there, your lordship. I am asking only 2, your lordship.
The petitioners counsel to furnish extra copies of the petition to the Learned Department Council within 2 days from today by obtaining written acknowledgement. Let this matter be listed again after 2 weeks so as to enable them to obtain instruction.
Deeply obliged.
30.
Yeah, another copy like.
তিনটা আছে।
My lord, the matter pertains to promotion of the petitioner, but the respondent authorities haven't filed any affidavit till today.
Who's the respondent?
GMC.
Did you submit any representation?
Yes, sir.
Where is it?
Annexure 12, lordship.
On Lakes in Court number 7, after some time, when it's possible. He's appealing for the.
No, but he has submitted representation. We'll ask the commissioner to consider it on.
Well.
Page number?
Page 58, lordship. Annexure 12.
And they have filed affidavit? No.
No, no, Lordship. Yeah.
Take down, heard Mr.
K Pujari.
K. Pujari, learned counsel for the writ petitioner. Also heard, should I record his name? Huh? Mr. P. Nayak, learned SC, GMC appearing for the respondents. Full stop. The writ petitioner hearing is serving as an assistant tax collector.
Assessment officer.
Assistant,
Assessment officer.
can you speak up a little clearly and loudly?
Lordship, a assessment officer. Lordship, we have filed an additional affidavit.
Holding the post of what?
Assessment officer, Lordship.
Assessment officer under the GMC. As per the statement made in the during the pendency of the writ petition, you have been promoted. Huh?
Lordship.
Yes, Lordship, I am promoted, but my grievance is different something, Lordship. It's actually one, in the GMC, before 2013, scheduler post is applied for promotion. And after 2013, staffing pattern came into force. But Lordship, one Modern Das employee, he has approached honorable
Then you
court for-
file another writ petition. Here your prayer was to consider you for promotion. They promoted you.
No, Lordship, assistant commissioner, because other incumbent has already drawing the scale of assistant commissioner, which is not in force. I have filed the affidavit, Lordship.
Listen. During the pendency of this writ petition, your client was promoted, is it not?
Yes, Lordship, promoted,
So
but
are you
not,
happy with that promotion?
Lordship, but my prayer was in the writ
Are you
petition.
happy with that promotion?
My claim was not there.
All right,
Lordship.
I'm disposing of. You are not answering the question of the court. The petitioner was aggrieved by non-consideration of his case for promotion to the next higher post, despite having continuously served in the same post for more than 9 years. First up, the petitioner had submitted a representation before the respondent number
3.
3, that is the Commissioner GMC. With a prayer to consider his case for promotion. Full stop. It appears from the statements made in the additional affidavit dated. Submitted a
Yes, sent to me.
representation dated
File another writ petition, question.
representation 17/12/2021, addressed to the respondent number 3 with a prayer to consider his case for promotion.
To the post of assistant commissioner, Lordship.
To the post of assistant commissioner under the GMC. Full stop. However, when no action was taken in the said representations, the petitioner has approached this court for filing the instant writ petition. Full stop. It appears from the statements made in the additional affidavit filed by the petitioner on 7/9/2022 that during the pendency of this writ petition, he was promoted to the post of assessment officer. Whereas one Sri Madan Das was given the charge of deputy commissioner in the Guwahati Municipal Corporation. Full stop. Although the incumbent Madan Das was junior to the petitioner. Was it your case?
No, Lordship, he's getting the scale of assistant commissioner, but I am not getting, Lordship. That is my case.
What do you want now? What do you want?
Promotion may be given, fill up the place of the assistant commissioner. That is only my.
But you have been promoted as assessment officer.
But the rule which is prevalent to prior to 2013, he is getting that scale. But
Then
as
you
per
have to
statute-
challenge, are you happy with the promotion to assessment officer? Yes or no?
my
All right,
prayer was
and you-
different to
you come
assistant
from-
commissioner, Lordship.
So and so, full stop. It is also the grievance of the petitioner that he has not been getting the scale of assistant commissioner. Full stop. Be that as it may.
Lordship, let them file affidavit that
Since the
later may-
petitioner has already been promoted during the pendency of the writ petition, the basic character of the petition has undergone change. Full stop. Therefore, unless proper pleadings are brought on record, it will not be permissible for this court to consider the prayer of the petitioner. More so, since he has already been promoted on 23/8/2022, and therefore, without proper pleadings, the request to consider him for promotion again to the post of Assistant Commissioner cannot be made. Under the circumstances, this writ petition stands disposed of by granting leave to the petitioner to avail appropriate legal remedy as may be permissible under the law. Why don't you understand simple law? You have been promoted
Once I am promoted,
in
Lordship.
2022.
Yes, Lordship.
Again, you want to be promoted now.
Lordship, because all the posts are vacant and only a graduate.
Where have you said that despite being promoted as assistant assessment officer, I still want to be promoted?
Yes,
Where is your
Lordship.
statement?
Bec-
Show me your statement. Now I'm going to dismiss it if that statement is not there. Where is that statement? Where is the statement that although I have been promoted assessment, I am entitled to promotion again to the next post? Where is that statement? Show me that statement.
Lordship, in my it's paragraph 2, Lordship, you have the additional affidavit, Lordship. I am not saying that, but there something is there, Lordship.
All right.
Paragraph
Writ
2,
petition
page
stands
number 61,
disposed
Lordship.
of. Yes, Mr. P. Naik. Disposed of, he has been promoted assistant assessment
Lordship, yes,
officer.
in
If
the
he is not happy, he is to file another writ petition. We
Yes,
can't
Lordship.
consider it
Yes,
as present writ petition. This
Lordship.
has completely changed the nature and character of the case. She is not understanding, make her understand. Yes, next matter, please.
Lordship, 23 to 2021. Lordship, I have annexed it. Page 44 of the writ petition, my lord. Just observation, this observation covers my
Page
case.
number?
44 of the writ petition, my lord. As regards any of the petitioners who may not have satisfied the requirement of having worked continuously for 10 years, we request the respondent APDCL to also consider their case and find out a suitable economic package for them as part of acceptability of the respondent ordered accordingly. Lordship, we are working as Lordship Sahayak, my lord, and your Lordship as meter reader. We have not fulfilled that criteria of 10 years, your Lordship, wherein this honorable court has held. They have said, yeah, our case is not covered.
Yes, Mr. Sharma.
Yes, my lord, their case is not covered. I have already filed my affidavit in opposition. My lord, their case is not covered because they have not rendered service. Their service they have rendered is less than 5
But
years.
she is seeking consideration under
Yes.
clause para 11 of the judgment.
My lord, with regard to that, my lord, what I am submitting here is that, my lord, the experience certificate which they have annexed, my lord, that is of 2018, and the advertisement they that we are talking about.
That you consider, we are not concerned with that. Only thing is they are less than 10 years.
Yes, my lord, they're
So
less than 10 years.
Less than 10 years also, there is some clause. You consider and see if there's something can be done for them as per the order of the court. That's all.
My lord, may I just submit one thing, my lord, as well. My lord, what in this case, those people had applied in the advertisement, and that is why the honorable.
You tell them that when they go. Don't tell us.
My lord.
Yes, heard Ms. B. Bhuya, learned senior counsel, assisted by Ms. B. Bora, learned counsel appearing for the writ petitioner. Also heard Mr. S. P. Sharma, learned standing counsel, APDCL, appearing for the respondents. Full stop. The petitioners herein are working as Sahayaks, stroke meter readers under the Hojai electrical subdivision of APDCL. Full stop. However, their services have not been regularized till today. Full stop. By referring to the judgment and order dated 23/2/2021, passed by the learned single judge in WPC number 1351 of 2020, Ms. B. Bhuya, learned senior counsel for the petitioner, submits that although her client's case would not come within the purview of the aforesaid judgment insofar as the relief granted to similarly situated relief granted to granted in respect of Sahayaks oblique meter readers who had completed more than 10 years of continuous service, yet in view of the observations made in para 11 of the judgment requiring the authorities to also consider the case of those Sahayaks oblique meter leaders who had not completed 10 years so as to find out a suitable economic package for them. This writ petition can be disposed of by directing the respondents to bestow adequate consideration to the petitioner's case as well. First up, responding to the above, Mr. Sharma submits that the writ petitioners herein are not eligible for consideration even under para 11 of the aforesaid judgment. Be that as it may, the question as to whether they are eligible, no, be that as it may, in paragraph 11 of the judgment and order dated so and so, a judgment and order dated 2021, the learned single judge has made the following observation. It is in page 44. Double tick to do it. Full stop. The above observation clearly goes to show that the case of those Sahayaks oblique meter readers who had not satisfied the requirement of having worked continuously for 10 years have not been outrightly rejected, but the respondents have been asked to suitably consider their case. First up, on such condition, whether the petitioners or any of them would be entitled to any relief or not is a matter of factual verification, which will depend on the representation and the documents furnished by the petitioners. First up, however, what is apparent is that even if the petitioners have not satisfied the requirement of continuous service for 10 years, even then their case would deserve some consideration by the judicial authorities, albeit not on equal footing with those who have completed 10 years of continuous service. First up, in view of the above, without expressing any opinion on the merit of the claim of the petitioners, this writ petition stands disposed of with a direction upon the respondents to consider the case of the petitioners in the light of observations made in para 11 of the judgment and order dated so and so as quoted above. Facilitating the above, the petitioners to furnish the petitioners to submit a proper representation along with supporting documents before the respondent number. Who will be the authority?
Chief General Manager, APDCL, my lord.
Before the respondent number 3.
CGM HRA. 3.
Within a period of 4 weeks from today, by enclosing a certified copy of this order. If such representation is filed, the same be considered in accordance with law and be disposed of by a reasoned order. Within a further period of 3 months. Within a further period of 3 months. Full stop. With the above observation, the writ petition stands disposed of. What is the IA for?
IA, it was lordship, I'm not pressing for IA. It may be disposed of, obliged.
If such representative file, the respondents will examine the claim of the petitioner in the light of the judgment and order dated so and so, as well as the provisions of law and pass a reasoned order. Yes.
Lordship, Mr. Mozumdar is called by court number 1, Lordship.
Last occasion, my lord, could
In this
direct
case,
it.
Lordship, I have received the instructions, Lordship, I will file affidavit. Lordship, may kindly allow me 2 weeks then to file affidavit.
Mr. N. Bora Learned Counsel is present on behalf of the petitioner. Ms. D. Bora Learned SC, Health and Family Welfare Department, Assam. submits that she has received instructions and be granted 2 weeks' time to bring the same on record in the form of an affidavit. You are therefore,
Yeah, I'm for the finance department.
Mr. B. Gogoi, Learned Standing Council Finance Department is also present. In view of the prayer made by Learned SC Health and Family Welfare Department, registered to list this matter again after 3 weeks as a fixed item. In the meantime, affidavit on behalf of the department be brought on record.
Much.
Obliged.
My lord, in this case, I'm appealing for on behalf of respondent 1 and 4 lordship. In this case, we have received instruction, my lord. 2 weeks time may be granted to file affidavit.
It's with regard to an appointment. He is an hearing impaired, my lord. He was selected in the combined competitive examination 2020 for the post of BDU. He was not given the appointment and the reason for that is not been disclosed. That much, my lord, will come.
Mr. UK Learned Senior Counsel is present on behalf of the petitioner, Ms. S. Chutia, Learned Standing Counsel.
My lord, I'm appealing on behalf of P Nayak, my lord. He's the standing counsel, 1 and 4, PNRD, my lord.
Appearing on behalf of the PNRD department, that is respondent numbers 1 and 4, submits that instructions have been received and therefore 2 weeks' time be granted for bringing the same on record. Mr. P.P. Dutta, Learned Counsel is present on behalf of respondent number 2, whereas Ms. A. Talukdar, Learned Government Advocate Assam, has appeared for respondent number 3. In view of the prayer made by the Learned Departmental Counsel, this matter is directed to be listed again after 4 weeks as a fixed item. In the meantime, parties to exchange pleadings, facilitating disposal of the writ petition at the stage of admission here.
My lord, the interim order will continue.
Interim order passed earlier to continue to that.
Much.
Bless me.
May I please, my lord? My lord, this is with regard to removal, dismissal from service of a employee of the Borpeta Road Municipal Board. My lord had on 15/3/23, my lord, while considering the matter, my lord, because considering my lord, the issues involved, directed them to produce the records. My lord, around, I think, my lord, what Das did also, they have not produced the records, my lord. And it's a matter pertaining to dismissal and I'm slated for retirement shortly, my lord. What had happened, my lord, there was an inquiry, there was a dismissal order which I put to challenge. This honorable court interfered with the matter, directed them to do a de novo inquiry within a time frame. My lord, forget the time frame, they have not done it. What they have done, my lord, they have conducted an inquiry behind my back. Only involvement of mine was my examination. And basing on that, my lord, they have come to a conclusion that the charges against me are proved. And then I was dismissed.
Yes, where is the record?
Your lordship, the additional AG Assam will be appearing. He will be here in a while, your lordship.
Will be coming.
Yes, he's on the way. He's just here. He's on the way.
Where has he reached?
He is in the court.
Find out how long, when is he arriving? Tell us. In the meantime, we'll hear him.
He is here, your lordship. I'm here on behalf of Madhuchanda Bhattacharya, madam, counsel for respondent number 4. Yes.
But he is coming.
Yes, he will be here in a while, as I'm told, your lordship.
But you are not sure.
I have been in contact with his juniors, your lordship. So I've been told he will be here.
Let us hope that you are right. Yes. Yes.
My lord, may come to page 36, my lord, the last order, the conclusion of that. This is an order dated 20/12/2021.
Yes.
Page 36. Well, this was passed in WPC 1710/2017, para 22. That being the position, the court directs as follows: the punishment imposed upon the petitioner by order dated so and so is hereby set aside and quashed. The respondent board shall start the proceeding de novo against the petitioner by issuing a fresh show cause notice on the basis of allegation of misbehavior threatening alleged by the then chairman, vice chairman, executive officer of the Borpeta Municipal Board. The entire proceeding shall be completed within a period of 6 months from the date of receipt of the copy of this order. Then, my lord, I was reinstated in service. And then, my lord, I was kept under suspension with regard with direction for payment of subsistence allowance. Now, para A, page 38, I submitted the copy, my lord, on 27/12/2021. Top, my lord. Page 40, my lord, would find the fresh show cause notice.
Page 40.
40, my lord. There were around 6 allegations against me. Then my lord would find at page 44 my reply. Now, my lord, as the proceedings were not completed within a period of 6 months, I had instituted, my lord, a contempt case, and that was pending before this honorable court. And finally, this honorable court, my lord, directed them to complete the proceedings. Page 61, they filed an IA also for extension of time, my lord. By order dated 30/11/2022, my lord may have page 62. The second last paragraph. In view of the aforesaid, this interlocutory application stands disposed of, granting time to the respondent authorities to complete and comply with the directions passed by this court in its order dated so and so by 16/12/2022. Now, what had happened was, my lord, they called me, I appeared, and at page 67, there is an undated report, inquiry report, which, my lord, was received by the board on 17/12/2022. Now, my lord would find the inquiry report, how they have dealt with. My lord may ignore the first page. My lord may have page 68, my lord. 3 paragraphs I like to place, my lord, here. Page 68. All were present on 28/11/22 at Barpeta Road Municipal Office, except the then executive officer, Manoj Sikumar Sikaria, who was engaged for some other work. At first, earlier list of allegations leveled against so-and-so was read out, and he was asked to submit his statement. He denied all the allegations. On the other hand, Santosh Poddar, Badal Mandal, Pulenda, Sabita Debnath has been asked for their statement regarding the matter. All of them retained their previous stand. On the same day, on being requested to provide allegations in writing, Sri Gunanjay Chaudhary, as asked, submitted his reply on or before 5/12/20. He denied all the allegations while his reply dated 5/12/20, receipt number so-and-so. Badal Mandal Santosh Poddar has informed by their letter dated 8/12/22, while receipt number 3619, that they has already submitted their inquiry report of department proceeding before the chairperson Savita Nath, dated so-and-so, and request to retain their previous report. So this all happening behind my back. Fulendas, while receipt dated so-and-so, and Sabita Debnath, while receipt dated so-and-so, dated 8/12/22, has stated regarding the misbehavior.
Mr. Majumdar, you are appearing for whom?
For the authority who has conducted this so-called inquiry.
The records are here.
Records are here.
No, the records, actually, we have collected half of the records, your lordship, but kindly grant us 1 week, a short date will be granted, your lordship. We have accumulated the records. Huh? For communication.
Lordship will give us a couple of days, the records.
Yeah, a very short date will be granted.
Otherwise, my lord,
We have the records, your lordship.
otherwise, my lord, I have gone through the petition. In the last section, this honorable court directed that this is not the way in which a disciplinary authority should conduct an inquiry. This time also, I find there is no difference. They are, my lord, an authority in themselves. They have done it in their own way. Then we have got a disciplinary appeal rules 1964. It is there in the rack. This is what I have noticed.
But if this time also it is the same, then who is the person responsible for this?
They are responsible.
No, we will drop contempt and call them. Yesterday also I have taken a similar view. The courts cannot be asked to do the same thing again and again.
Right.
If there is a clear direction or reasons given, if the same is repeated, first we'll deal with the contempt, then we'll see.
And my lord, I have ensured that my learned colleague, Mrs. Bhattacharjee, tells them specifically that there is a rule in the Assam which governs the procedure in which a disciplinary proceeding is to be.
Mr. UK Nair, learned senior counsel, has appeared on behalf of the petitioner. Mr. D. Majumdar, learned additional AD, Assam, appearing for the respond numbers. Appearing for respond numbers.
My lord, my senior would be appearing for.
I'm appearing for the municipality, not as an additional AD, my lord.
Achha.
For the municipality.
He'll be more for respond number 4 and 5.
Respond numbers 4 and 5. And sought posting of this matter again on 30th of May 2023, so as to enable him, the state respondents one opportunity to produce the records pertaining to the inquiry proceeding. Prayer allowed as last chance. Registered to list this matter again on 30th of May 2023 as a.
Only one thing possibly at last we'll have to find out. whether the petitioner himself is the architect of all these things.
That you find out, but if the same thing is
Because
repeated,
last time also same thing
the
happened.
courts will not
Yes,
go on to
Why
the
not?
same thing again and
this
again.
number Clearly indicated in the last order.
All right, next.
Much
Fine.
more, 30.
Yes,
May it please the lordship. Well, in this case, my lord, I am challenging the selection of the private respondent, my lord, as Gao Pradhan on the ground that he is not qualified to hold the post. And I'm, my lord, praying for a writ of.
he is
God.
already holding the post of Gav Pradhan.
No, he has not been appointed. He has
Then
been
this is not maintainable. This writ petition is premature. That's why, Mr. Saikia, the other day I said, apply your mind and act like a lawyer. You are asking a question to quo warranto, what authority he has to hold the post of Gav Pradhan. He is not holding the post of Gav
He
Pradhan.
has been selected, my lord.
He may not be appointed.
Then, my lord, worship, my lord, direct the commissioner to, my lord, dispose of the
We will
appeal.
close the matter today, holding it as premature. That's
My
about
lord,
all.
directing the, my lord, commissioner to, my lord, dispose of the appeal which is pending before the
That
commissioner.
is already passed, that order.
No, in this case, not passed, my lord.
No, your lordship needs to see the prayer portion. He is challenging the select leave. By writ of.
All right, we'll ask the commissioner, divisional commissioner to expedite disposal of the appeal.
Yes, my
Before time.
Appeal, that was in 195 WPC. In
Already
terms
there.
of the order of the honorable court in 195, he has preferred the appeal.
That's all right.
And then your lordship has disposed of it.
All right, heard Mr. I.H. Sekal, learned counsel appearing for the writ petitioner. Also heard Mr. B.C. Das, learned senior counsel assisted by Mr.
S.H. Raman.
S.H. Rahman, learned counsel appearing for respondent number 6. Mr. S. Datta, learned S.C. Revenue has appeared for respondent number 1 and 2, and Mr. D. Bora, learned Government Advocate Assam for respondent numbers 3 and 4.
3, 4, 5.
By 3, 4, 5, full stop. By filing this writ petition, the petitioner has prayed for a writ of quo warranto. Spelling to silent. Quo warranto. Questioning the authority of the petition of the respondent number 6 to hold the office of Gav Pradhan. Full stop. However, the fact remains that the respondent number 6 is yet to be appointed as a Gav Pradhan. Full stop. The instant writ petition has been primarily filed on the ground that having been selected for appointment in the post of Gav Pradhan, he is likely to be appointed soon. However, merely on the basis of likelihood of the respondent number 6 being appointed as a Gav Pradhan, a writ of quo warranto would not lie. Full stop. At this stage, it has been brought to the notice of this court that the petitioner has already preferred an appeal before the divisional commissioner of Lower Assam division under Rule 162 bracket C of the executive instructions framed under the Assam Land and Revenue Regulations 1886, assailing the selection of the respondent number 6 for appointment as Gav Pradhan, and the said appeal is pending disposal before the concerned appellate authority. In view of the above, by providing that the appeal preferred by the petitioner be disposed of expeditiously and within the statutory period, this writ petition stands closed.
In the meantime, my lord.
You cannot get any, you see, I can dismiss the whole thing, but you can't get. This is just a personal rivalry. Sorry, nothing.
My lord.
Your client is not entitled to any relief.
Oblige.
May I please, your lordship?
Yes.
I'm appearing on respondent number 2 and 3.
Yes.
Lordship, order is already complied with. And we need 1 week time to file affidavit, lordship.
No affidavit, where is the order complied?
Lordship.
Yes. Order has been complied with.
As per my instruction, no.
Yes, we'll retain the, you have got a copy of the order?
Today itself I got this.
Yes, we'll close it. Heard Mr.
You Soikia.
You Saikal, learned counsel for the petitioner. Also heard Miss
K Borpujari.
K. Borpujari, learned counsel appearing for the respondent numbers 2 and 3, who has produced a copy of the order dated
But
26/9/2019,
may submit your lordship.
issued by the State Chief Commissioner, Bharat Scouts and Guides, Assam, to submit that the order of this court has already been complied with. Full stop. A perusal of the order also goes to show that the same has been issued in compliance with the order of this court dated 22/8/2019, passed in WPC number 129 of 2017. If that be so, by retaining a copy of the order dated 26/9/2019 in the record of this case, this contempt case stands closed. The petitioner would, however, be at liberty to assail the order dated 26/9/2019 if he is dissatisfied, if he is not satisfied with the said order passed by the authority. Contempt case stands closed. Yes.
Problem.
Lordship made pieces. In this case, your lordship, my learned friend was given last chance to obtain instruction. Why the
Well,
order
here,
is
my
not
lord, as,
complied with?
the opinion was sought for from the Advocate General on the last occasion I submitted. Accordingly, my lord, as per opinion, my lord, we have prepared the review petition against this particular order. There are two orders, my lord.
Which is the order? Let us.
Yes, lordship, may
Lordship,
kindly
may-
have a look at
Page
page,
35 to 39.
no, page 18, my lord. for a
That is
moment.
the first order.
Yes. Page 18. By this order, my lord, the present writ petitioner was directed to be regularized in a personal post. That lordship will find at page 22. Para 9.
Regularization of service.
Regulation of service, my lord, left out master of local government after
Not
Umadip.
the left out his misreading.
let him
the
do
order.
that.
Yes, let him complete.
Now, my lord, when my lord, the process was not completed, though initiated, my lord, the petitioner again approached the honorable court. That order is at page 35.
Left out means from that 1993 process.
No, yes, no, my lord, of the 2005 process. 1/4/1993 is the cutoff date, my lord.
Why was he left out?
My lord, according to the authorities, that is the other main administrative department, instead of the present petitioner, somebody else was regularized with the same name.
Right?
Now, my lord, in page
That is
30
a mistake on the part of the department.
but my lord, we have taken a stand of the finance department is that, my lord, whatever, my lord, be the issue. After Uma Devi, my lord, in fact, my lord, in this regard, we preferred a, my lord, miscellaneous application before the division bench also. At the time, my lord, when a taken up matter was,
And which order has not been complied with? Which is
my
the order?
lord, here, my lord, they
Subsequent
praised, my
order.
lord, the subsequent order,
Page 39.
page 36.
Yes.
But this order is a consequential order of the first writ petition, my lord,
Mm-hmm.
page 36.
Yes.
There, my lord, a proposal was mooted.
Hmm.
And my lord, page 38, lordship will see, the Commissioner and Secretary Irrigation Department and Civil Engineer Irrigation Department was directed to do the needful as provided in the communication dated 1/10/2020 within a period of so and so. Thereafter, they moved the Finance Department. And the Finance Department, my lord, rejected that proposal on the ground that, my lord, after Upendas and Umadevi, they cannot be regularized. And in the meantime, my lord, we got a notice of this
So
contact.
finance department has set aside the order of the single judge.
No, my lord, they were actually, my lord, they were not
No
aware.
order of
So
rejection.
immediately they sought for the opinion, my lord, that what should be done now in the present situation. And accordingly, we have prepared a review petition in both these cases. And my lord, by today, we are trying to file it by today if we get a copy of that, my lord, signed review petition. But by Friday, it will be filed anyhow, my lord. Lordship, give us some time, my lord. In
We'll have
fact,
it on
legal papers are
Wednesday.
pending in this regard.
Wednesday and then
Yes.
we'll pass a strict order here.
Lordship, let it be on Wednesday.
You have time till Wednesday, whatever you want to do. Heard Ms. B. Bhuya, learned senior counsel appearing for the petitioner. Also heard Mr. B. Gogoi, learned standing counsel, finance department, as well as Mr. N. Upadhyay, learned counsel appearing for the respondent numbers 2 and 4. Who
I appear for
who
3 months.
prayed for posting this matter again on 31st of May 2023, so as to give them a final opportunity to instruction. Prayer allowed, list again on 24th, 31/5. Mr. Gogoi, we are not interested what
I understand. my
the
lord.
opinion of the learned.
No, I'm
AG
not
is.
on that, my lord. But
You either give a stay order or there will be direction for personal appearance.
my-
I'm making it
I
very
will
clear.
convey, my lord. Obviously.
Whatever you want to do. But the state is entitled to
Yes.
explore its remedies.
Lordship,
But then the court proceeding will go as per the proceeding.
lordship.
This is the order of 2021.
Main
So-
order is of 19, my lord.
Sorry? Ah.
2000.
So, yes, you can expect a order on the next date. Even if you file a review petition without a stay, that order is coming.
Actually, my lord, the main bench probably is not available.
No, whatever you do,
We'll-
you file review or appeal, that's your prerogative, but we will have to go with the process of the court.
I understand.
That's as simple as that. Yes.
Your lordship, in this matter, I would like to seek further 3 weeks' time. We have not received any instructions.
Yes, Lordship.
Yes, Ms. G. Swami, Learned Counsel for the
Lordship,
petitioners.
D Swami.
That's right. Mr. D. Bora, Learned Government Advocate Assam has appeared and prays for further 4 weeks' time to obtain instruction. Prayer allowed. Let this matter be listed again after 6 weeks.
Obliged.
My lord, this matter has come for the first time, my lord, for issue of notice.
B. Chetri and Bhagini Sailabo, willful, alleging willful violation of services also. 8 weeks, huh? How many respondents?
Only mainly two respondents have been directed. my lord.
Respondents. Multiple respondents. Registered for today. Yes, 8 weeks. This is also first listing, R. Pukar. Bagi kini hai ke? Order to side go. None appears for the petitioner on call. This matter still passed to approval.
This is also first time it is.
First time, Mr. B. Chetri, 8 weeks.
Lordship.
Silent of any multiple. Messages.
My lord. My lord, AG is not AG is coming. AG is supposed
We'll
to-
start with
Yes.
you. What is the matter?
No, they have
Who
filed an
get-
they have filed an IM. my lord.
Yes.
Coming, just coming.
You start, you can't ask the court to wait. We'll pass over the matter then. Next week.
Time being, my lord, just coming there. Thank you.
In this matter, selection of Gowda was made under Selene.
Hmm.
Was brought under Selene. The projected case is that it is because the subdivisional assessor is the appointing authority. But
IA is for vacating state.
yes, Lordship, because subsequently, the subsequent executive notice notification, it is the deputy commissioner. And in fact, it was not appointment, this is the selected list of selected candidates.
Where is the order passed by the court? Page number?
It's 26/4/2023.
No, is it a part of the IA?
No, lordship.
No, Lordship.
No, lordship, it is not.
Bring it with the IA.
Lordship, and there is a fundamental mistake. There is no prayer for vacation of stay of that. That is my.
So today I have been engaged, Lordship. In
Then
fact,
we withdraw and file a
Lordship,
petition.
Lordship,
That is,
I-
there is.
Mr. UK Datta Learned Counsel for the petition applicant seeks leave of this court to withdraw this IA with liberty to file a fresh.
highly pressed.
Mr. BP Vora Learned Counsel for the writ petitioner stroke OP is present and does not have any objection if the prayer is allowed. In view of the above, this IA stands disposed upon withdrawal with liberty as transport. Yes.
Deeply obliged, Lord.
Lordship, in this case, the BTC has filed a IA praying for leave to constitute the CSB. There is an order of this honorable court. If Lordship is pleased to take my IA at page 21. The Central Selection Board that was constituted in 2018 for a period of 5 years, Lordship, and it was dissolved during the period of 5 years. Lordship, they challenged it before by filing the writ petition, and while admitting this case, a notice was issued on 24th of August 2020. There was an observation at page 22. May I read that part?
Yes.
After hearing the learned counsels, this court is of the opinion that the interest of justice would be made if a direction is given that in the event the elected body or the respondents intend to constitute a fresh selection board, the same would be done only by taking leave of this court. So we have filed this IA seeking leave of this honorable court. In any case, their term is going to be over next month. They have filed an objection saying that we are trying to modify the order. It is not for modification or cancellation of this order. The order itself has granted us permission that if we have to constitute a central selection board, which is very much necessary for all kind of selection. At present, there are about 1,000 posts vacant. We are not being able to recruit anybody because this board is not functioning. And that board is a part of that MOU, Lordship, entered in 2002 or 2003, Lordship. So in if Lordship is pleased to take the writ petition, there is a mention of this board. This is a mandatory requirement in BTC. 5.4, page 25 of the writ petition. Down below, BTC shall also be competent to make appointments for all posts under its control in accordance with the rules of appointment followed by the government of Assam. However, the post where recruitment is to be made on the recommendation of APSC shall not be covered under this provision. The council may constitute a selection board for appointment to be made by it and also make rules with the approval of the governor of Assam to regulate appointments and ensure adequate representation of all communities living in the council area. So this is a requirement under this arrangement, Lordship. So in that view of the matter, Lordship, this board is not functioning for last from 2000. The impugned order was issued way back in 2020. Yes, 22/6/2020. It was considered 22nd of June 2018, and it was dissolved on 28th June 2020. So exactly after 2 years. So for last 3 years, it is not functioning. 1 month short of 3 years. So our submission would be, Lordship, that as because we have given the numbers also in our IA, how many posts are lying vacant because of non-functioning of this board. In our affidavit, we have stated page 14 of the IA, paragraph 4.
So there was no interim order by this court, is it? Was there any interim order?
No stay order.
No stay order.
No stay order. Only observation that if we have to constitute a new board, we have to seek leave.
Yes.
Manoj, may kindly take up the judgment for a moment, the order, Manoj.
Yes.
Okay. Manoj, come to the last two paragraphs. After hearing the learned counsel, this court is of the opinion that the interest of justice would be made if a direction is given that in the event the elected body or the respondents intend to constitute a fresh selection board, the same would only be done by taking leave of this court. It's the next paragraph, the last paragraph. Pleadings may be exchanged before the next date so that an early date of hearing can be fixed in this matter. If the pleadings are exchanged prior to the returnable date, an endeavor would be made by this court to take up the matter for disposal. Now, my lord, till date, my lord, a period of more than 2 years, 8 months have elapsed, my lord. no pleadings have been filed, my lord. There is no affidavit in opposition, either denying or admitting these grounds on which the writ has been filed. My lord, may I kindly take up my objection for a moment, my lord? I'll just read one paragraph of my objection.
So you are saying that decide the writ petition.
My lord, what I'm trying to say, my lord, that this, my lord, the direction seeking leave of this court is a protection given to the petitioner. It's an interim order. And this IA is essentially an IA for vacation of the stay order. My lord, there are judgments to this effect, my lord, the judgment by the Honorable Division Court, Division Bench, where it has been held, my lords.
So
That-
how is your client's interest protected here? You are not the board now.
We are not the board, my lords. If a new board is elected, constituted, I'm sorry, my lords, then our matter would become infructuous. Now I have,
Will make it clear that it will not become infructuous.
my lords, I have judgments to that effect, my lords, wherein, my lords, under
Mr.
similar
Mohanto, whether your clients will be restored back or not.
yes,
That could be a legitimate question.
my lords,
But for that, thousands of appointments should be held up.
my lords.
How does it make a difference to the public who is in the selection board, whether your client or anybody else is there?
my lords,
How does
Lordship
it make a difference?
I'm so, well, with all due respect, my lord, Lordship would put that question to the respondent authorities, my lord. What were they doing since 2 years,
Right.
8 months?
Merit
There's a
on the
clear
IA.
direction, my lord.
What else do you have to submit on
My
the?
lord, Lordship, can you take up my objections for a moment?
Yes.
Kindly, my lord. Just one paragraph, my lord, bit longish, my lord. I'll just read it out, my lord. Paragraph 4.
Where is the objection?
The affidavit in opposition filed against the IA, my lord. It's on record, my lord. You mentioned it
Yes.
on the last occasion.
Yes.
Lordship, take up page 26, paragraph 4, my lord.
Yes, please.
That with regard to the statements made in paragraph 2 of the interlocutory application, the answering deponent humbly begs to state that although the order dated so and so passed in the connected writ petition directed the respondent authorities to seek leave for constituting a fresh selection board, the said order also provided that pleadings in the connected writ petition may be exchanged before the next date fixed, so that an early date of hearing can be fixed. However, the respondent authorities have till date not filed their affidavit in opposition, admitting or denying the contention raised in the writ petition till date, although a period of 2 years and 8 months have elapsed from the date of passing of the said order. The answering deponent further begs to state that the order dated 24/8/2020, if perused in its entirety, will disclose that the direction to the effect that fresh CSB shall not be constituted without the leave of the court was in fact an interim order protecting the interest of the petitioners who contend to have been illegally removed from their post. Therefore, the instant interlocutory application is essentially an application praying for vacation of the interim order. As such, while disposing of the instant application, the Honorable Court may be required to delve into the merits of the matter and consider the application on the legal yardsticks pertaining to grant of interim orders. The answering deponent also humbly begs to state that the instant interlocutory application, apart from seeking leave of this court, does not raise any grounds whatsoever as to why interim protection granted to the opposite party's writ petitioners shall be vacated. Further, since till date no counter affidavit has been filed by the applicants, the case of the respondents is also hit by the doctrine of non-traversal, which is specifically provided under Order 7, Rule 5 of the CPC. In view of the aforesaid circumstances, it is humbly prayed that the present interlocutory application may be dismissed. Now, my lords, there is a judgment which covers our case, my lord, judgment rendered by the Honorable Division Bench, my lords, wherein it was said, my lord, it was provided that where there is a tenure fixed, so this body had a fixed tenure of 5 years, CSB. Where there is a tenure fixed, there cannot be, they cannot invoke the doctrine of pleasure, my lord. It is not at the pleasure of the governor or the government, because there is a tenure, my lord, and the guidelines which provides for removal.
So, Mr. Mohanto, when no protection was granted, no interim relief was granted to your client, in the sense that they were not continued in office. That happened in 2020, right? We are in 2023. What action has your client taken before this IA was filed? That is the question. Would you please address the court on that? Your clients never wanted to come back to office.
We wanted, my lords,
But you did not take
because
any
the
step.
impugn order had already taken effect. That's why it could not have been, there could not have been a permanent mandatory
Right.
injunction. my lord.
So therefore, your stand is that whenever you succeed in the writ petition, Your clients will be back in office, right?
And restored, my lords,
And restored.
to their
So
original
whenever
position.
you succeed, you'll be restored.
My lords, in that case.
Otherwise, the other way is your client's tenure is ending next month.
No, my lords, that's, if I may place the judgment for a moment.
You can, but
My lord, the judgment, while deciding the matter, my lord, which is similar.
we will go by public interest, Mr. Mahanta. You complete your arguments. You private and why have you been waiting since last 3 years?
My
If
lord,
there is a judgment which says this is that, that is that. You never approach the court for expediting the hearing. Today, when they have come for a leave to constitute a board, now you want the court to sit tomorrow, next day and finally hear the matter.
all due respect, it's the other way around, my lord. We filed the writ petition. There was a clear direction by this honorable court
Yes.
that you exchange pleadings, my lord.
Yes.
They have not filed their counter till date, my lord. I'm ready to argue the matter, my lord. Lordship would
All right, please conclude. Please conclude. Let us
take
pass.
up the entire matter, my lord.
No, only the IA. Only the IA.
And there's not a single ground, my lord, denying or my lord, admitting the grounds what we have raised, my lord.
Right. And which judgment you want to rely? You pass on the.
Reported in 2017, 5 GLR 177. My lord, I provided this book list. No, sir. His lordship would find the facts in paragraph 2, my lord.
Yes.
The state government by an order.
What is the law? Why are you relying on this judgment? For
Well,
what purpose?
Well, because to my lord, show that the termination of the board was not legal.
We'll
was-
give you early hearing. Give you early hearing, but that will be in July. Because you have not taken any steps. That's all. Yes.
My lord, also direct, my lord, in the event we succeed, my lord.
Yes, that will be there. The only reason the court is not with you is that you asked for a stay order to allow your clients to continue in office. That was not granted by the court. Last 3 years, you took no steps to expedite the hearing of the writ petition. Today, when the state has come, the authorities have come saying that allow us to constitute a board because the public employment is being stalled. Just because some private individuals are interested in the matter and their tenure is expiring next month, we will say that we'll hear the matter and then pass a final judgment only because some petitioners want that kind of an order. You expect the courts to do that? Where is the bona fide of the petitioners here? Why did you not come 1 year back, 2 years back? You also were interested that, all right, we don't want it, but just let the matter be lying that way. Is it a stand taken in public interest? Heard Mr. Saikal Lanet's Advocate General Assam.
As a senior standing counsel of
Senior
CTC.
Standing Counsel BTC appearing for the assisted by Mr.
Arkim, sir.
R.K. Mosari appearing for the applicant. Also heard Mr. P. Mohanto, learned counsel appearing for the writ petitioners stroke opposite parties. Full stop. Take down. The as per clause
5.4.
5.4 of the memorandum of settlement dated, is there any date?
Yes,
10 to 2013, my lord.
Dated 10 to 2013, entered into by and between the Bodoland Territorial Council bracket BTC and the state of Assam. The BTC authorities are required to constitute
Date is
a central
10 to 2003, Lordship, not 13.
10
I'm so sorry,
to
10 to
2003
Noted.
are required to constitute a central selection
Noted.
board
Noted.
for conducting
Needed or not.
the selection process for making appointments within the BTC area. Full stop. Accordingly, by notification dated 22/6/2018, the Central Selection Board constituted by the writ petitioners, all the writ petitioners were notified by the authorities, full stop. However, subsequently, the secretary of the BTC, that is the respondent number 4, had issued the principal secretary BTC, that is the respondent number 4. No, when was the council notified?
Notified, my lords, page 51, 2206/2018, my lord.
2206/2018. And when was it dissolved?
2006/2020, my lord.
2020.
2006/2020.
It was dissolved on 26/2018.
It was
It was first
constituted-
dissolved and then constituted.
No, my lords, it was first constituted on 2206/18. Thereafter, it was dissolved on 2006/2020, my lords.
22nd June 2018, it was constituted.
And it was dissolved
Dissolved on 20th,
2006/2020.
20th,
26/2020.
Lordship.
So you made a wrong this thing in the synopsis. That's why I'm confused.
Let's
Look at the second line. Cancelled, you said 26/2018
I
was.
corrected it in my copy. I'm sorry.
Oh, you corrected in your copy.
Sorry. my lord.
26/2020. The appointment stroke nomination of the petitioners as chairman and members of the Central Selection Board was cancelled, aggrieved by the order dated 26/2022. The chairman and the members of the CSB had approached this court by filing the connected writ petition. Full stop. After hearing the submission of learned counsel for the parties, this court had passed order dated 24/8/2020 in the connected writ petition, issuing notice. Full stop. There was no stay order restoring the writ petitioners back in office. Full stop. The learned single judge had, however, observed that in the event the elected body or the respondent authorities intend to constitute a fresh CSB, the same be done only by taking the leave of this court. Full stop. The present application has accordingly been filed by the BTC as well as the principal secretary to the BTC as applicants seeking leave of the court to constitute the CSB. Full stop. By referring to the statements made in the application, Mr. Saika submits that the term of the board constituted by the writ petitioners as chairman and members would in any way come to end on 21/6/2023. However, the restoration of the petitioners is not possible unless they succeed in the writ petition. On the contrary, there are thousands of posts lying vacant in the BTC area which could not be filled up till today due to the absence of the CSB. Therefore, the authorities have approached this court seeking leave of the court, approached this court by filing this IA seeking leave to constitute CSB. Full stop. Mr. Mohanto, on the other hand, has argued that since the respondents have not filed pleadings despite the order of the learned single judge, this matter be taken up for hearing at an early date. Until then, no such leave be granted. Full stop. Granted. By referring to a decision of the division bench of this court rendered in the case of Subdivisional Welfare Board for Scheduled Tribes and others versus the state of Assam, represented by the Commissioner and Secretary, Welfare of Plain Tribes and Backward Classes Department and others, reported in
17/5 GLR 177.
2017 5 GLR 177. Mr. Mohanto submits that in case of statutory bodies which have a fixed tenure, doctrine of pleasure cannot be invoked to dismiss such body. Therefore, submits Mr. Mohanto, his clients have a good case of merit. First up, the learned counsel for the petitioner, however, submits that ever since 24/8/2020 till the time of filing of the present IA, the read petitioners have not made any prayer before this court for expeditious hearing and disposal of the read petition, although they were out of office in the absence of any interim order passed by this court. Full stop. What is to be borne in mind that a read court will always give primacy to the public interest at large over private interest of some individuals. Full stop. If the BTC authorities are unable to fill up thousands of vacant posts due to absence of a CSB, it cannot be said that the leave as sought for from this court should be denied merely because it subserves the private interest of the read petitioners. In any case, see, the read petitioners are out of office in the absence of a specific direction stroke order from the court. They cannot be restored back in office. Full stop. As such, leave as prayed for by the applicants is hereby granted. The applicants may proceed to constitute a new CSB as per the requirement of law. However, constitution of such CSB shall be subject to final order that will be passed in the connected read petition. With the above observation, this IA stands disposed of.
And this order may be notified to the CSB, newly constituted, so that no third party rights appeal.
It will be subject to further orders, final order passed in the read petition.
They will notify that to the newly constituted CSB, so that no third
It
party
is,
right.
they know it, they will do it.
There-
Once
this
the
will be
court passes an
conditional.
order, whether they notify or not, it will cover. But Mr. Mohanto,
My lord.
you see, you do your job as your counsel.
Hmm.
But the read courts will always give primacy to public interest
Absolutely.
over private interest. That is the fundamental, unless there is a malafide in the action.
Understand.
Yes.
Highly obliged.
Deeply obliged, ma'am.
Well, not in this matter, the revenue department as well as personnel department has filed their affidavit. We'd like to file a short reply, a short 1 week's time may be granted, my lord.
My lord, we have filed our affidavit, my lord. The lordship only if a date is fixed, my lord, on
Yes, yes, yes.
on first
Can
of
you agree on a date?
on
both of
first
you?
on
Yes.
1st of June, my lord.
1st of June.
1st of June. Some urgency is there on our part, my lord.
All right. All right, Mr. Ken Chaudhary, Laris Senior Counsel, assisted by Mr. P. Mahanta, has appeared for the applicants and submits that a copy of the objection filed on behalf of the department in this IA has been recently served upon his junior, and therefore he be granted 3 days' time to file rejoinder. A prayer allowed. Mr. D. Nath, Learned Additional Senior Government, Learned Senior Government Advocate Assam, and Mr. J. Handik, Learned SC Revenue Department, have both expressed urgency in the matter and have made a request to post this case again on 1st June 2024. Prayer allowed. List this case again on 1/6/2023 as a fixed item. Interim order passed earlier to continue till then.
Deeply.
May I please, your lordship? My lord, the IA for correction of typographical error, my lord.
What is the
My lord,
typographical?
due to our bona fide mistake, my lord, respondent number 5 has been written as Bagbor Revenue Circle, my lord, instead of Bornagar Revenue Circle, my lord. In the writ petition, page 4, my lord, as well as order dated 12/5/23, my lord.
You want what correction?
My lord, in place of Bagbor, it should be Bornagar, my lord only.
Where?
In writ petition, cost title, my lord, as well as.
Writ petition cannot be corrected. The
Yeah.
order does not say Bagbor. Order says
Sir,
Barnagar.
my lord, in the cost title of order also, my lord.
First title, you seek amendment of the writ petition. I can't pass an order correcting the writ petition. Sorry, there is no correction in the order. Order says Barnagar.
My lord, in the order, page 3, my lord. Respondent number
Oh,
5,
that is because you mentioned it in the writ petition.
my lord.
How can this court correct the writ petition? You make an application for amendment of the writ petition then. You said this is an application for correction of typographical error in the court order. There is no typographical error.
My lord.
Yes.
As well as-
Anyway, heard miss, your name please?
And Nasrin, my lord.
N. Nasrim, learned counsel for the applicant. Also heard Mr. J. Henry, learned standing counsel Revenue Department Assam, as well as Ms. A. Talukdar, learned counsel appearing for the state of Assam. This IA has been filed with a prayer to correct typographical error in the order dated 12/5/2023. According to Ms. Nasrim, the concerned circle officer is of Bornagar Revenue Circle within courts, but it has been erroneously mentioned in the writ petition as Bagbor Revenue Circle in case of respond number 5, full stop. Hence, the prayer for correction. However, it has been pointed out by the learned departmental counsel that error is due to an incorrect representation by the petitioner in the writ petition itself and not due to any error in the order of this court. Be that the order of this court. In view of the above, this court is of the opinion that there is no typographical error in the order dated 12/5/2023 passed by this court in WPC number 2285 public 2023. However, by clarifying that in view of the stand taken by the applicant's counsel, the concerned circle officer in this case shall be treated as Bornagar Revenue Circle Officer. This IA stands disposed of.
Obliged, my lord.
My lord, matter may be fixed next week.
What is the matter?
Affidavit in opposition as filed today only, my lord.
Yes.
You want to obtain instruction and file rejoinder. Have you received copy of the
Yes,
affidavit?
yes, Lordship. Yes.
All right, heard Miss
R. Shah, Lordship.
R. Shah, learned counsel for the writ petitioner submits that she has received the copy of affidavit in opposition filed by the BTC authorities, that is respond numbers 1, 2, and 3,
Yes.
and therefore be given 2 weeks time to obtain instruction and file rejoinder if so advised. Mr. R.K. Mushahari, learned standing counsel BTC, is present on behalf of the respondents. On the prayer of Ms. Shah, this matter be listed again after 3 minutes. Yes.
Documentary list for order.
Yes.
May I please, your lordship?
Yes.
Lordship, before I start, my lord, I like to draw some points, my lord, before lordship, my lord. Before perusing the document, my lordship, may I kindly come to first page number 14.
No,
of the-
where is the order of the court?
My lord, that is my lord. Page
Page?
14.
Page 14, yes.
Yes, my lord. Page 14, operative part, my lord. Mr. A. Setri, my lord, third paragraph. Mr. A. Setri, learned counsel appearing for the director of pension, and MS B. Datta, learned counsel appearing so and so. They have not object if the writ petition is disposed of with a direction to the authorities to examine the case of the petitioners, and if they come within the ambit of the notification dated 3/7/13. The petitioners should be given the legitimate dues, and
Do
thereafter,
they come within the ambit of notification?
yes, that, no, my lord.
They don't come.
No come.
Have you informed them?
My lord, lordship may kindly my
No,
instruction.
no, no. Have you passed an order informing them?
My lord,
that they don't
problem is that, my lord, that notification was before this passing of this order, that was withdrawn, my lord, by the department.
So pass an order
Yes,
informing.
but department is trying to save them, my lord. That is why again the department has proposed the.
No, my lord, kindly see the affidavit of. All right, then you tell the department to pass an order and close it.
My lord, my
Because
lord.
he is also not willing to relent.
My lord, my
He
lord,
is pressing and we will issue personal appearance.
my lord, I'll lordship may grant 7 days.
Pass-
I'll.
yes.
Yes,
Pass an order, reject their claim.
my lord,
That will close.
my lord.
Heard Mr. M. Islam, Learned Counsel for the petitioner. Also heard Mr. M. Daftar Learned
S.
Counsel, S. Daftar Learned Counsel for the respondent.
Respondent, my lord, on report request I appeared, my lord.
On the Learned Counsel for the respondents who
PNRD department may be referred.
Learned Standing Counsel PNRD Assam, who seeks posting of this matter again on 2nd of June 2023, was to come up with the final order
order.
from the authorities.
Fine.
They are allowed.
Fine.
Is this case according? You reject it, they'll
Yes,
find
yes,
it in
yes.
India's.
Well, obliged, my lord.
Highly obliged. It's-
When the order has been complied with. And the amount of 19 lakhs, 11,558 had already been deposited to the account. My lord.
You'll also receive instruction from the client that no calculation details have been given, so it's difficult to assess.
No, order has been complied with, payment has been made 19
But
lakhs.
this is not the full payment, the lordship.
Then you have to file a writ petition. All right, heard
Calculation-
Mr. Your
if-
name,
If the
please?
calculation details are provided, then
Your name, please?
J Das on behalf of SP Roy.
Mr. J. Das, Learned
Next
Counsel,
page, my lord.
has appeared for the petitioner. Mr. R. Bora, Learned
S. Bora.
S. Bora, Learned Standing Counsel, GMC has produced a copy of the order dated 23/5/2023, passed by the law officer.
Next
GMC.
page. will be, my lord.
No.
Next page is the 11. my lord.
Annexing a copy of the
Transaction, my lord, voucher, my lord.
transaction stroke transfer voucher to submit that a sum of rupees 19 lakhs 11,558 has already been deposited in the account of the petitioner in compliance with the court order. At this stage, Mr.
J. Das.
J. Das submits that no calculation sheet has been furnished to the petitioner, as a result of which he is unable to verify whether the amount is correct or not. Since Mr. Bora has undertaken to furnish a calculation sheet to the petitioner on behalf of the GMC within 3 weeks from today, this contempt case stands closed by granting liberty to the petitioner to approach this court once again by filing proper writ petition if he continues to remain aggrieved in the matter. You have this copy.
No, I will provide him.
You provide this. Problems.
Problems.
No, this matter, I have received instructions, my lord.
What is the instruction?
My lord, the instructions which I have received, my lord, earlier, my lord, a representation was submitted challenging the transfer, which was rejected on 17/3/2023.
But rejection was.
My lord, the summer change was the communication dated 17/3/23. So now, my lord, another representation has been submitted, my lord, which perhaps, my lord, is not permissible. Already authorities have considered and rejected the claim against transfer. And now, my lord, relieving order has also been issued, my lord, 16/5/23.
A relieving order has been issued, but.
So what is the ground on which?
My lord, the disease from which she suffers, my lord, she's getting her treatment here at Guwahati. Now she's at the group center, my lord, which also has a composite hospital, and my lord, there is a coordination there.
Is transferred from Guwahati to?
My lord, Bangalore to a battalion, my lord. Although it is called Bangalore, but it is a battalion which does not have a composite hospital. And the coordination for her illness. my
All right,
lord,
heard Mr. R. Majumdar, Learned Counsel for the petitioner, also heard Mr. H.K. Gupta, Learned CGC, appearing for the respondents. The writ petitioner has approached this court by challenging the impugned transfer order dated 2/3/2023 on the ground that she is presently receiving medical treatment post eye surgery.
My lord, the other part also, my lord, she's suffering, she's taking medications for antiretroviral, my lord, which is called immunodeficiency, my lord. It's
They'll have to pack up, but we'll give you 1 week's time. The submits that the petitioner is receiving treatment for immunoretroviral.
Madam, there is HIV, madam. She's an HIV positive.
HIV. Human
Deficiency.
immunodeficiency syndrome virus, Beckett's HIV. At the medical center at Guwahati. And if she is transferred and posted in a battalion at Bangalore, her treatment will be hampered since there is no specialized medical center at the battalion
At Bangalore.
battalion camp. Full stop.
There is a center, my lord. I have received instruction, my lord, in Bangalore. She will have that facility, my lord. The instruction
Only
is
government hospital.
no.
Mr. Gupta, however, submits that the petitioner would get
Bangalore
the same facility even at Bangalore.
Metropolitan City.
Composite hospital.
Huh?
The composite hospital of the respondent authorities where she's now serving, it has a composite hospital. There
However,
it
the
is
learned
facility.
CGC could not appraise this court as to whether there is a composite hospital of the
Respondents.
respondents at the battalion reserve. Full stop. In view of the above, this matter is directed to be listed again on 31st of May 2023 as a fixed item for motion, so as to enable Mr. Gupta to obtain updated instruction status quo as regards the posting of the petitioner. Yes.
Your Lordship, I'd like to beg to mention item number 36, Your Lordship. We were given the date 30th of May. However, I've just been informed by my senior that she will not be present here on 30th of May, and with the consent of the other side, Your Lordship may kindly grant us first the date of 1st June instead of 30th May.
All right.
We have taken the consent of the other side, Your Lordship. 1st June. Obliged, Your Lordship.
Whoever has taken the order, tell him.
36.
Yes.
On last occasion, Lordship has asked me a pertinent question regarding Lordship the recruitment rules, which is applicable in my case, and the procedure for direct recruitment. And I have find out the rules. Assam Service Direct Recruitment Class 3 and Class 4 Post Rule 1997. That is the rule applicable in this case. And the procedure has been laid down in Rule 4, how to advertise the post and how to recruit the post, whoever the selection committee. So as per Rule 4.2, appointing authority shall advertise the vacancy, giving details about reservation for the reserved categories and other necessary particulars by displaying the advertisement in the office board of the office of the appointing authority. In addition to the copies of the advertisement shall be sent to the following offices as stated below for display in their respective office notice board. In case of district level office or any office below that level, deputy commissioner of the district in which the office of appointing authority is situated, all subdivisional offices, all block development officers, all revenue officers in the district in which the office of the appointing authority is situated, all employment exchange in the district to which the office of appointing authority is situated. So in this particular case, no advertisement has been issued, only notice has been issued. So Rule 4 has been specifically violated. Secondly,
please take your seat. Let us find out from the departmental
Lordship,
counsel.
record.
The only issue is that if it is illegal, then he can't get seniority.
If route is goes,
If it is not illegal but irregular,
Lordship.
then
Lordship.
will not get into
Lordship.
it. It has to be illegal.
Lordship, records are with me, Lordship. Lordship may kindly.
No, you first make your submission. Yes.
Lordship.
How, what was the, which rule was followed in this case?
Lordship. As per my instruction,
Take out
Lordship,
the-
Assam Ministerial District Establishment Rule 1967 was followed. Under Section 6, recruitment. It has been stated that recruitment to the service shall be made by the appointing authority according to the procedure laid down below. For now, it has been updated to junior assistant. Earlier, it was lower division assistant, Lordship. Page 197, Lordship.
Yes. You want to
By-
show which rule?
Lordship, Assam Ministerial District Establishment Rule nineteen
Assam
sixty-seven,
Ministerial District Establishment Rule 1967.
page 194 is the recruitment, Lordship.
Yes.
Section 6, Lordship. Recruitment to the service shall be made by the appointing authority according to the procedure laid down below. Then Lordship may kindly peruse page 197, Lordship,
197.
97.
Yes. Junior assistant.
Junior assistant by direct recruitment on the basis of a competitive examination consisting of an objective type written test and computer proficiency test, practical, as laid down in Schedule 1 of these rules, to be conducted by the Deputy Commissioner at the beginning of each year for any vacancy in the post of junior assistant likely to occur in the course of the year in the respective establishment unless otherwise directed by the government in this behalf. Lordship, at this time, this computer test was there, is there, but during that time, no computer was there. There was a typewriting test. And according to records which I have received, typewriting test was conducted as well as the written examination was also conducted. Lordship, the result of the typewriting examination are in record, Lordship. Actually, and moreover, the notices, the notice was sent to the office of the District Employment Exchange also, Lordship. From the notice, it has been, I came to know, Lordship.
Notice was sent to the District Employment Exchange.
Lordship, there is a record also, Lordship.
Yes. Yes.
The marks which the candidates has obtained are here only, Lordship, in the records only, Lordship.
No, that is not under his selection is not under challenge.
Lordship,
They are on the procedure adopted.
Lordship,
According to them, first his initial, if I remember correctly, argument was that though he should have been reverted back,
Lordship,
instead of doing, he has been regularly absorbed as an LDA.
LD.
Perhaps later on, once these materials came on record, then it turned out that there was some process initiated by the division, concerned division, based on which the private respondent was appointed as an LDA, then an LDA. So then the case of the petitioner was that this process is dehorsed the rules.
Lordship,
Therefore, his appointment as LDA is illegal.
illegal.
If that be so, even if the petitioner was appointed after the respondent number 5,
Lordship,
he ought to be given seniority.
Lordship,
And therefore, if there is a consideration for promotion on seniority criteria, the petitioner should get priority.
Lordship,
That is the case of the
Gotcha.
petitioner. So the only question there that can arise now is the appointment of the respondent number 5 in the post of LDA dehorsed the rules. So you say the recruitment was done as per Rule 6
Rule
of the
6.
rules of 1967
Lordship, Lordship,
as amended,
Lordship,
in the sense that the computer was not there earlier, it was typewriting.
typewriting.
And you say that there was a circulation notice issued
Yes,
in
Lordship,
the office board and also to the employment
Employment
exchange.
exchange.
Candidature was called.
Lordship, Lordship.
There were how many? 3 candidates.
No, 5 candidates were applied. 5 candidates had applied and 3 candidates had sit in the exam, Lordship. The application forms and all the details are there in the records only, Lordship, of the all the 5 candidates, and 3 had appeared, Lordship. All those 5 had applied, Lordship.
All right. Which is the latest writ petition?
It is
WPC?
2959.
Right. Can you pass over the record, please?
Lordship.
Yes. Now, in this WPC number 2959 of 2023, the notice issued on 24/9/1993 inviting applications
Lordship,
for filling up one vacant post of LDA has been challenged.
sorry.
And what is WPC number
Lordship, I have,
Six
I have given the written argument where Lordship, I have quoted in the first initial page regarding all the three cases.
written argument, where is it?
Details of the case I have given in the initial page, Lordship, which are filed for which.
So now the respondent number 5 is working as senior assistant.
Duties.
Petitioner and respondent number 5,
Both.
both are working as senior assistant. So they were promoted from UDA to senior assistant. That is junior assistant to senior assistant. No, but how Assam Public Service direct recruitment to class 3 and class 4 posts?
May I
rules
read,
of-
Lordship?
One
May-
minute, 1 minute. Rules of 97
Lordship,
can be used to make an appointment in the year 1993 or 4.
Lordship. That rule in existence earlier, unamended rule also dear Lordship, that unamended rule also dear, same rule is the unamended rule also, same rule. That is why Lordship, I am pointing out the rules.
But he is referring to another rule.
No, this is Assam District Ministerial Establishment Service rule. That is a district, in the office of the Deputy Commissioner, that rule is followed. That is why Lordship, the Assam Public Service Direct Recruitment Class 3 and Class 4 rules 1997 specifically provided when any department including public work department and other work department, no rule is provided, then this rule is applicable. There is no, Assam Water Resource Department has no direct recruitment rules conducting recruitment for appointment class 3 and class 4 posts. There is no service rule. That is why this rule specifically stated that Assam Public Service Direct Recruitment Rule class 3 and class 4 is applicable. Section 3 specifically stated also. May I?
Yes, 1 minute, just 1 minute. Now, you have relied upon the OM dated 5th of November 1999, which imposes a ban on appointment of casual employee.
No, no,
casual
no,
work-
no. This is not relevant now, Lordship.
Ah,
This is not relevant now.
This is not relevant.
The
So
only thing is,
only issue is whether his appointment is legal or not.
Lordship, only question is whether his initial appointment is illegal or legal. There is no recruitment rule for recruitment from the works as employee to the LD extent. As per recruitment rule, there is no reservation for works as employer Khalasi in the recruitment rules. Lordship, may I read Assam Public Service Direct Recruitment Class 3 and Class Post Rule Section 3. These rules shall apply only
That is
to
in which page?
Section 3, Lordship. All rules.
Which page of the book? Assam, what is the name of the rule?
Assam Public Service Direct Recruitment to Class 3 and Class 4 Post Rules 1997.
Yes, 115, okay. Yes.
Section 3, Lordship. These rules shall apply only to those classes of Class 3, both technical and non-technical, and Class 4 post, where there are no service rule executive orders regulating the recruitment and condition of service and not within the purview of the commission. So Water Resource Department has no recruitment rule for Class 3 and Class 4 post. Technical or non-technical. And rule
But
where
this is a rule which was framed in 1997.
1997, and Before that also, that rule is there. This
Where is it? Where is it?
Unamended rule. I got rule. That is it.
Does it repeal? Which rule does it repeal?
No. Not repeal, Lordship. This is Lordship will find.
Hmm.
This has been notified in August 1997. No amendment found till 2006. It was
No, Mr. Goswami, the problem is the rules of 97 will have nothing to do with this case.
Lordship.
Unless you can show a
Connecting regarding Lordship 1993.
It has to be mentioned in 97 rules.
That have to be Lordship
It has to be mentioned in the 97 rules.
97
Otherwise,
rules.
It must say that those provisions of the previous rules will be continued here, mutatis mutandi, without any, then only you can make this argument.
Lordship,
Otherwise you can't.
I have verified, I have inquired in the office of the Lordship this Water Resource Department. They have said that this rule has been followed from earlier stages, but in the rule itself, it is nothing in the that 1993 is applicable. I have verified in the office, Lordship. He has said Assam District Ministerial Establishment Service Rule is applicable. That is also Lordship will find Assam District Ministerial Establishment Service Rule. That is also Lordship.
All right, you call day. Yes.
Assam Ministerial District Establishment Service Rule 1967. If that is also applicable, Lordship, then also there should be an open advertisement and there is no procedure for a recruitment from the workers' Khalasi. It should be an open advertisement. Page 9 of our written argument, Lordship, we have specifically point for determination, we have stated, Lordship.
So you are giving up the argument that he was appointed as Khalasi and this was a personal post, so he was illegally promoted as LDA. That part you are giving up.
This
You are
is
not-
recruitment. This is recruitment. Recruitment to the.
No, Mr. Goswami, I'm saying that argument you are giving up. Because there are pleadings, I have to deal with it in the
Lordship.
judgment. Yes. What is WPC number 5684 of 2023? It is another writ petition.
The filing number, my lord, that has now been converted into this.
That has been converted to 2959.
All right, and where is the gradation list in the writ petition? First, the provisional gradation list. So, Mr. Goswami, I think it's time to put an end to this.
Only thing is, may I submit two things, Lordship. As per recruitment rules, if Lordship Assam District Ministerial District Service Rule is applicable, there are two procedures for giving appointment to the post of LD assistant. One is direct recruitment to the post of LD assistant. One is from the seniority come merit from the grade 4 staff. Two procedure. There is no provision for recruitment from Khalasi or Raksas Khalasi. In the earlier rule, that is Assam Ministerial District
Right,
Service.
you argued that point.
Lordship. There is no rule for recruitment from workers Khalasi. And I have already pointed out that there is no advertisement for the post. Only a notice was given specifically to the private respondent and to some persons for applying for the post of LD assistant. There is no open advertisement. Article 16 of the Constitution of India specifically stated.
These are subsequent
Lordship,
judgments.
Lordship.
93, those
Lordship,
judgments were not.
Lordship, no. Article 16 of the Constitution specifically stated that it should be open to all. It is a direct recruitment post.
Mr. Goswami, if you argue these things, I'll have to write a big judgment, but the result will be the same. I'm dismissing all the writ petitions.
Lordship.
There's no case made out by the petitioner. What is the point in it? 1993, those judgments were not applicable. Newspaper publication, employment exchange was the only way of going forward in these matters. It was a regular sanction post. They have invited applications. Petitioner was one of them. There was a selection committee, selection board constituted, written and typewriting test was held. Then on merit he was appointed. That's the end of the matter. That's the end of the matter.
Lordship, I understand what Lordship has pointed out. I have pointed out. I have.
But yes, if as I made it very clear, if there was any hanky-panky in his recruitment, then only your client will have a case.
Lordship.
No
That
otherwise.
is my case, Lordship. That is my case. Only case
You
is.
have argued already.
Lordship, that is my case that there is no recruitment rule for providing for Waxas Khalasi to the post of LD assistant. These notice has been issued for Waxas Khalasi only. There is no open advertisement.
All right. All good things must come to an end. Now you will take over.
No, Lordship. We have a larger issue in our hands, Lordship. Whether the post of LDA in the Water Resources Department can be filled up from within the departmental candidate or
You
not.
file a PIL on that.
No.
I'll give you liberty. There's nothing to go into all these things. What larger issue? Why have you come now? Because you want to
Lordship,
get
because I am
promotion.
affected in the year 2022, immediately I have approached this court. Now, if your Lordship, I will read the Article 16 once, Lordship, if your Lordship permits me.
Yes.
Equality of opportunity in matters of public employment. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any offices under the state. This is Article 16, Lordship. I am arguing on this point. Article 16, whether it can be filled up or not.
Mr.
And Bormon, Lordship.
He has already argued the case. Now you argue, but if you fail, I'm going to impose 50,000 rupees cost on your client to be recovered from his salary. Because he has argued whatever he has to argue.
No, the point.
Now you cannot take over from him and start a fresh argument. That is not permissible.
Lordship, with your Lordship's permission, the part that has been left out, I just want to submit that part.
What part has been left out?
This part has not been dealt with.
We will not allow you to raise these questions in this writ petition. I am rejecting that prayer. You argue that these things cannot be allowed now. In the first day, it was made very clear that if his recruitment is prima facie found to be derogates the rules, he will not get the seniority over the petitioner. Otherwise,
I have challenged the recruitment initial selection process of the respondent number 5, Lordship, on the ground that it's the same is illegal. Why illegal? If your Lordship come up to the notice I'm taking out WPC 2959, Lordship.
Hmm.
The advertisement itself says,
Has this not been argued by Mr. Goswami?
no,
Mr. Goswami, you have not argued this part.
I have shown the notice.
I'll just, if your Lordship permits me,
I'll give you 2 minutes. You don't have
application,
any case.
application from Wheeling Work Charge SA Tracer Khalasi of this division who has got the requisite. That means all the Khalasis who were within the department were supposed to be informed.
Yes, yes.
Whether they have been informed, that part. has not
Are you
been-
holding the brief for them?
No, till that the department has not filed any affidavit.
No,
Lordship.
that's
In
not
fact,
it.
Lordship, I can give the names of the persons who were working in this department today, who were Khalasi in the year 1993, but his name, he was not given the notice. With authority, I am making this submission before this court. Let the department file an affidavit, Lordship. We want to argue this case, Lordship.
All right, you argue. Well, I'll hear whatever you argue. You argue.
Now, Lordship, in Mamta Mohanty's case, Lordship, para 35. At one time, this court has been of the view that calling the names from employment exchange would curb to curtain extend the menace of nepotism and corruption in public employment. But later on came to the conclusion that some appropriate method consistent with the requirements of Article 16 should be followed. In other words, there must be a notice published in an appropriate manner calling for applications, and all those who apply in response thereto should be considered fairly. Even if the names of the candidates are requisitioned from the employment exchange. In addition thereto, it is mandatory on the part of the employer to invite applications from all eligible candidates from the open market by advertising the vacancies in newspapers, having wide circulation, or by announcement in radio and television, as merely calling the names from the employment exchange do not meet the requirement of said article of the Constitution. Para 36, therefore, it is a settled legal proposition that no person can be appointed even on a temporary or ad hoc basis without inviting applications from all eligible candidates. If any appointment is made by merely inviting names from the employment exchange or by putting a note on the notice board, etc., that will not meet the requirement of Article 14 and 16 of the Constitution of India. Such a course violates the mandates of Article 14 and Article 16 of the Constitution of India, as it deprives the candidates who are eligible for the post for being considered. A person employed in violation of this provision is not legally entitled to any relief, including salary. For a valid legal appointment, mandatory compliance of the said constitutional requirement is to be fulfilled. The equality clause enriched in Article 16 requires that every such appointment be made by an open advertisement as to enable all eligible persons to compete on merit. Now, Lordship, the articles at the post of LDA is a public post. It is open to the public. Whether the department, Water Resources Department, by way of a recruitment process, can conduct a selection process within the department when Khalasi is not an eligibility criteria for selection to the post of LDA. The criteria isn't the person has to be a HSLC pass. Now, Lordship, if your Lordship, today we consider that the persons within the department, that means if we consider the qualification, only 5% in the year 1993 will have to be only pass the matriculation. The rest of the brothers, in the broader sense, the public was not allowed to participate. That is my case, Lordship.
Very good case. Yes. Anything else?
That's all, Lord.
You want to add anything else?
No, Lordship.
Huh? You want to add anything else, you argue?
No,
Otherwise,
I have given, I have given a set of judgments, if your lordship, I can.
No, unless you say what is the point, no question of allowing you to rely on judgment. And only once you tell the court what is the point, and for that,
Prima
what-
facie, I am submitting before this court that the entire selection process was illegal on the ground that the persons who were.
why did you remain silent for 30 years?
I was not affected. I was not affected till the year 2022, lordship. When the moment I got affected, I immediately approached this court.
Oh, so whatever has happened 30 years will get wiped out only because you are affected. You are not aware of this? That
No,
he-
not
he-
at all, lordship. After getting the RTI reply that I have annexed, lordship. If you're, in fact, the RTI reply that has been given by the department is also false, lordship.
All right,
I can show it from record, lordship.
all right, yes. Yes.
That's all, lordship.
All right. Yes, what do you have to say?
I have submitted the list of dates, my lord, that your lordship directed me to on the last occasion. That covers perhaps everything that, but from respondent 5's point of view, my lord, whatever in the case that has been provided in a concise manner in that list of dates with arguments that covers everything if your lordship takes up. My lord, this will, my lord will peruse it, or I have to point it out, my lord, or my lord will peruse it, my lord, because it is chronologically provided right from the very.
All right, I'll go through.
Obliged.
Yes, take down hard, Mr. S.K. Goswami, counsel appearing for the writ petitioners in WPC number 6236 of 2022 and WPC number 6052 of 2022. Also heard Mr. N. Burman, learned counsel for the writ petitioner in WPC number 2959 of 2023. Full stop. Mr. R.M. Das, learned standing counsel, Water Resources Department, has appeared for the official respondent. You are also there, Mr. Nayak, you are also appearing in this case? What is that? Respondent numbers 1, 2, and 3. Mr. Nayak for respondent number 4 and Mr. D. Chakravarti, learned counsel for the private respondent number 5. Full stop. All these 3 writ petitions are connected to one another and ultimately seeks to assail the appointment given to the respondent number 5 in the post of LDA so as to wipe out the benefit of seniority in the gradation list, seniority of the respondent number 5 in the gradation list, full stop. Such challenge is also directed towards nullifying the such challenge is apparently made with the view that if the seniority, if the respondent number 5 is denuded of his seniority on the ground that his initial appointment was illegal, it is the writ petitioner who would rank senior in the list of in the gradation list of senior assistants and therefore would be eligible for promotion to the next higher post of superintendent in the Department of Water Resources, full stop. The facts of the case necessary for disposal of all the 3 writ petitions may be briefly noticed herein below, full stop. The respondent number 5, namely, what is his name?
Sukhendra Narayan
What is-
Thar.
Sorry?
Sukhendra Narayan Thar.
Whatever the name, Sukhendra.
Sukhendra Narayan Thar.
Was initially appointed as a ward judge bracket WC, W/C, bracket close, Khalasi, under the Silchar Flood Control Division at Silchar, wide office order number 215 of 1990-91. Full stop. His engagement as a W/C Khalasi was extended from time to time. Full stop. On 24/9/1993, the executive engineer, Silchar Flood Control Division, had issued a notice inviting applications from persons having the requisite educational qualification and knowledge of typewriting for filling up one vacant post of LDA in the said division. Full stop. In response to the aforesaid notice dated 24/9/1993, the writ petitioner along with, then you write, it appears that apart from circulating the notice, the authorities had also intimated the district employment exchange about the recruitment process. Full stop. In response to the notice dated 24/9/1993, as many as 5 applications, including that of the present respondent number 5, were received by the authorities. Full stop. On scrutiny of the full stop. Accordingly, a selection board was constituted for holding written examination and typewriting test of the applicants. Full stop. Out of the 5 applicants, only 3, including the respondent number 5, had participated in the written test and typewriting test, whereafter the respondent number 4 had scored the highest mark, bracket 40, bracket close. Consequently, order of appointment dated 7/3/1994 was issued, appointing the respondent number 5 in the post of LDA under the executive engineer Silchar F full stop C full stop division full stop. After rendering continuous service in the post of LDA for nearly 7 years, the respondent number 5 was promoted, and the service of the respondent number 5 was confirmed as an LDA with effect from 1/6/2001 by issuing notification number 74 of 2001-02 dated 7/8/2001 full stop. Thereafter, wide order dated 01/03/2008, the respondent number 5 was promoted to the post of Upper Divisional Assistant, bracket UDA, bracket close, now renamed as Senior Assistant, comma, full stop. On the other hand, the writ petitioner was appointed as a Junior Assistant, bracket LDA, on 19/2/2011, pursuant to his merit position in a direct recruitment process initiated by the executive engineer, comma, Water Resources Division, bracket erstwhile FC, bracket close, Silchar, full stop. On 27/10/2017, the writ petitioner was promoted to the post of Senior Assistant, bracket UDA, in the office of Executive Engineer, WR Division, comma, Silchar, full stop. Thereafter, a provisional gradation list of senior assistants in the Silchar WR department was published on 14/2/2022, wherein the name of the respondent number 5 appeared at serial number 1, whereas the writ petitioner's name appeared at serial number 2, that is below the respondent number 5, full stop. Not being satisfied with the said provisional gradation list, the petitioner had submitted an objection before the departmental authorities. However, since no action was taken on such objection submitted by the petitioner, he had approached this court assailing the provisional gradation list of senior assistants by filing WPC number 3727 of 2022, a provisional gradation list of senior assistants published on 14/02/2022 by preferring WP bracket C number 3727 of 2022, which was disposed of by the learned single judge at the stage of motion hearing by order dated 06/06/2022, with a direction upon the respondents to consider the representation dated 17/02/2022 submitted by the petitioner and take a decision in the matter within a month from date of receipt of a certified copy of this order. Accordingly, the objection stroke representation submitted by the writ petitioner was examined by the chief engineer from a water resources department, whereafter his claim was found to be untenable. Accordingly, by the speaking order dated 08/09/2022, the representation submitted by the petitioner against the provisional gradation list dated 14/02/2022 was rejected. Aggrieved by the order dated 8/9/2022, the writ petitioner had filed WPC number 6052 of 2022. Meanwhile, on 13/9/2022, the department had published the final seniority list, final gradation list, not seniority, gradation list of senior assistants under the Silchar WR departments, wherein the position obtaining in the provisional gradation list dated 14/2/2022 was maintained. Situated thus, WPC number 6052 of 2022 was filed by the petitioner, assailing the final gradation list dated 13/9/2022. When writ petitions being WPC number 6052 of 2022 and WPC number 6236 of 2022 were pending disposal before this court, it appears that the petitioner had obtained certain information by filing application under the RTI Act 2005, whereafter WPC number 2959/2023 has been filed challenging the notice dated 24/9/1993 issued by the departmental authorities, inviting applications for filling up the post of LDA, against which the respondent number 5 was appointed way back in the year 1994. Full stop. Next para. Mr. Goswami, learned counsel representing the writ petitioner has argued that although the case originally projected in WPC number 6052 of 2022 was to the effect that the respondent number 5 having been engaged in as a ward charge khalasi, and the said post Warchas Khalasi, he could not have been promoted to the post of LDA in as much as there is already a office memorandum dated 5/11/1999, as well as a subsequent order issued by the Water Resources Department on 28/8/2017, directing reversion of all such WC Khalasis. Yet, at this point of time, the only issue pressed by the petitioner is pertaining to the validity of the process through which the respondent number 5 was appointed as an LDA. Mr. Goswami has further argued that although his client is not seeking an order from this court terminating the service of the respondent number 5, yet the question of validity of his appointment in the post of LDA is being raised in these proceedings only to show that the appointment of the respondent number 5 was divorced the rules, and therefore he cannot claim seniority over the writ petitioner, even though he was appointed on a prior date. Full stop. By placing reliance on decision of the Supreme Court in the case of State of Orissa versus Mamata Mohanty, reported in 2011, bracket close 3 SSC 436, Mr. Goswami has argued that the respondents would have to maintain complete equality in the process of public employment. First of, since the notice dated 24/9/1993 had invited applications only from Warchers, Khalasis, stroke, tracers, etc. Hence, it cannot be said to be an open selection process filling up a post through direct recruitment. First of, by contending that the procedure adopted for recruitment of the respondent number 5 ought to have been one as provided under the Assam Public Service bracket direct recruitment to class-Roman 3 and class-Roman 4 posts bracket close rules, 1997 bracket rules of 1997. Mr. Goswami has argued that no such procedure had been followed in this case. First up, it is also the submission of Mr. Goswami that the authorities could not have filled up the post of LDA through direct recruitment without issuing wide publication of the advertisement notice and giving an opportunity to all eligible candidates to participate in the recruitment process. First up, on such count, it is the forceful submission of Mr. Goswami that no benefit of seniority can be given to the respondent number 5 over and above the petitioner, since his initial entry into the service is illegal. Full stop. Mr. N. Burman, learned counsel for the writ petitioner in WPC number 2959/2023, has also reiterated the same arguments and submits that The notice dated 24/9/1993 itself being illegal and dehorsed the provisions of rules. The appointment of the respondent number 5 to the post of LDA cannot be held to be valid. Full stop. To that extent, the respondent number 5 cannot claim seniority over the writ petitioner. Full stop. Next, Mr. R.M. Das, Learned Standing Council Water Resources Department, has produced the records pertaining to the selection process and also submits that the recruitment in this case was done. And submits that the procedure followed while issuing the notice dated 24/9/1993 was the one laid down under the Assam Ministerial District Establishment Service Rules from 1967. According to Mr. Das, Rule 6 of the Rules of 1967 lays down the criteria for filling up the post of LDA, now redesignated as junior assistants, and the procedure followed in this case is strictly in compliance with Rule 6 bracket sub-rule 6 of the Rules of 1967. Full stop. Next, Mr. D. Chakravarti, Learned Counsel for the respondent number 5, has also argued that the challenge made to the appointment of the petitioner, besides being dehorsed, besides being devoid of any merit, is also barred by time, since the petitioner was all along aware about the procedure through which the petitioner was appointed as an LDA, but had failed to question his appointment at the relevant point of time. Full stop. It is also the submission of Mr. Chakravarti that the petitioner, having been appointed as an LDA much later than the respondent number 5, he cannot claim seniority over the respondent number 5 in any view of the matter. Full stop. I have considered the submissions advanced by the Learned Counsel for the contesting parties and have also gone through the record produced by the Learned Departmental Counsel. Full stop. Since Mr. Goswami has submitted that he is not pressing the challenge made to the appointment of the respondent number 5 on the ground that he was liable to be reverted to the post of Warchas Khalasi, this court need not be detailed on the said aspect of the matter. First of, it is clear from the arguments advanced by the petitioner's counsel that their only objection is pertaining to the procedure followed while appointing the respondent number 5 in the post of LDA. Full stop. There is no controversy at the bar that unless it can be shown that the appointment of the respondent number 5 was dehorsed the rules and therefore illegal, only then illegal. The question of the petitioner gaining seniority over the respondent number 5 in the gradation list would not arise. First of, therefore, the core issue that would arise for consideration of this court in the present batch of writ petitions is whether the appointment of the initial appointment of the respondent number 5 in the post of LDA was dehorsed the rules. Full stop. As noted above, it is the stand of the Learned Departmental Counsel that the authorities had followed the provisions of Rule 6 bracket 6 of this Service Rules of 1967, full stop. As such, Rule 6(6) is reproduced herein below for ready reference. It has to be quoted. Full stop. Rule 6 as amended from time to time is reproduced herein below. Full stop. A perusal of the departmental records goes to show that the Executive Engineer Silchar FC Division had not only issued notice dated 24/9/1993, but intimation was also sent to the local employment exchange, inviting applications, pursuant whereto 4 other candidates had submitted their application. Full stop. The duly constituted selection board had also subjected the 3 candidates to a written test and typewriting examination, and upon evaluating the results, it is the writ petitioner who had scored the highest mark. Thereafter, order of appointment dated 7/3/1994 was issued in favor of the respondent number 5. Full stop. Full stop. Rules of 1967 as amended, bracket close, does not lay down any requirement to issue advertisement by newspaper publication. Full stop. Moreover, there is no dispute about the fact that at the relevant point of time, conducting recruitment process by calling applications through the employment exchange was a permissible mode. Full stop. Therefore, merely because there was no newspaper publication of the advertisement notice, this court is of the view that the appointment of the respondent number 5 cannot be termed to be illegal only on such count. Full stop. It is not the case of the writ petitioners that the appointment of the petitioner of the respondent number 5 was not against a sanctioned vacant post, or that no proper selection procedure was conducted before issuing him the appointment order. Full stop. It is also not the case of the petitioners that the respondent number 5 did not have the requisite qualification under the rules for being appointed as an LDA. Full stop. Merely because the notice had indicated that applications were called from willing WC Halasis, SA, WC Halasis, S and A, SA. What is SA? Section assistant, bracket SA, oblique tracer, oblique Khalasi of third division. That by itself cannot render the notice as invalid in the eye of law. More so, none of the intending candidates have ever questioned the validity of the notice issued by the departmental authorities. Full stop. Full stop. From a careful analysis of the materials available on record, this court is of the opinion that the appointment of the respondent number 5 was against a valid post of LDA, against a vacant sanctioned post of LDA, and his appointment was made in accordance with the provisions of rules of 1967 by holding a proper selection process. If that be so, there is no scope for this court to hold that the appointment of the respondent number 5 in the post of LDA was vitiated in any manner. Full stop. once it is held that the appointment of respondent number 5 in the post of LDA was in accordance with law, the question of assigning him a lower position in the gradation list of section officer, that too under the writ petitioner, would not arise in the eye of law. Full stop. This court therefore finds itself in agreement with the views expressed by the learned by the Chief Engineer, Water Resources Department in the order dated 8/9/2022, rejecting the application submitted by the writ petitioner. Full stop. The decisions relied upon by learned counsels for the petitioners were not in the context of the rules of 1967. Therefore, this court is of the opinion that the decision rendered in the case of Mamta Mohanty was in the facts and circumstances of that case and would not have any application in the facts of this case. Full stop. There is yet another aspect of the matter which deserves mention here in that. Full stop. There can be no doubt about the fact that since the date of appointment of the petitioner as an LDA on 19/2/2011, he was aware about the fact that the respondent number 5 was senior to him in the cadre of LDA. Full stop. Full stop. However, at no point of time did the petitioner raise any question either about his seniority or the validity of his initial entry in the service. It was only when the procedure for promotion of eligible senior assistants to the post of superintendent, divisional head assistant in the Silchar Water Resources Department was initiated, that this writ petition was filed. Full stop. It has already been noted herein that the sole purpose of instituting these writ petitions were to denude the writ petitioner, respondent number 5, of his seniority after the lapse of nearly 30 years from the date of his original appointment. Full stop. Such an attempt on the part of the petitioner is found to be is not found to be bona fide nor in accordance with law, and therefore deserves to be strongly deprecated by this court. Full stop. For the reasons stated herein above, these writ petitions are held to be devoid of any merit, and the same are accordingly dismissed. The interim order dated so and so, passed in WPC number. What is the date of interim order?
Passed in 6/2/36. The interim order was dated 21/9/2022.
The interim order dated 21/9/2022, passed in WPC number 6/2/36 of 2022, is hereby vacated. It would now be open for the departmental authorities to process the candidature of eligible departmental candidates for promotion to the post of senior divisional assistant in accordance with law, if so advised. In view of order passed here, the IA number, what is the IA number?
My lord, my IA for vacating, my lord, is IA number 544 of 2020.
Mr. Goswami and Mr. Burman, you have done your job. You have tried. Leave the decision to us.
Okay. Lordship is correct. I'm obliged for
Correct or not correct?
No, no, I'm obliged for that. Lordship has correctly pointed out. Only thing is, Lordship has only recorded one thing, that I am aware at the time of recruitment. Before I get to LD post, he is already promoted.
That you have to challenge. That is the view
No,
of the.
before I joined the LDA system, Lordship has wrongly recorded that I have no LDA system. He has earlier promoted the post of EDSA before actually.
No, that's right. So the idea was to say that his existence in the department was known. If these matters were raked up 20 years back, the matter would have been very different. All right.
Obliged.
The record